Oyez, oyez, oyez. All manner of persons who stand bound by our cognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. I see we have a full house here today. I'd like to welcome you to our third and final day of our fall argument session here in our magnificent Harrisburg courtroom. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America, and our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Judiciary Act of 1722, and in 2022, we celebrated our 300th anniversary with a special session in Old City Hall in Philadelphia. We on this bench are very proud of our rich history. Over the past 26 years, I've had the privilege of sitting on the bench in this majestic capitol as architect Joseph Houston envisioned this building to be a palace of art. I encourage everyone in attendance to visit the rotunda, the legislative chambers, and the governor's reception room with an eye toward the beautifully crafted artwork, particularly the famous Violet Oakley murals installed in 1927, which you can see adorn this courtroom. Violet Oakley was the first American female artist to receive a major public art commission, and her murals on the evolution of law are simply spectacular. Ultimately, she devoted 25 years of her life from 1902 to 1927 to painting 43 murals for this capitol. I trust that no one who works here takes this gift for granted. While there are many things that our three branches of government may disagree on, I know that our judiciary, along with our legislature and executive branch, all agree that we have been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals in our magnificent capitol. This courtroom was designed in the Greco-Roman style, as indicated by Ionic columns and the Greek grille wainscoting, all handcrafted. All of the wood in this room, including the bench, is mahogany imported from Belize. I'd also like to draw your attention to the 4 huge chandeliers, which I'm told, I've not tested this, I've been told they each weigh 2 tons. They are unique, yet different from one another. Under the main light in each is a statue dedicated to 4 great lawgivers. To my right are the Hebrew lawgivers. Closest to the bench is Moses, and in the back is King Solomon. To my left are the Greeks. Closest to the bench is Aristotle, and in the back is Solon, a foundational figure in Athenian democracy. Solon laid the groundwork for modern democracy by making laws fair and expanding political participation. The majesty of this courtroom is designed to remind us all of the seriousness and importance of the work we are here to do. We have some students visiting with us today. They are college students from Alvernia University, and they are here with their constitutional law professor, Dr. Victoria Williams, and also with them is Vice President of Advancement and Government Affairs at Alvernia, Tom Minnick, and I'd like you to stand so we can recognize our students. Welcome. The court is always happy to welcome students, and I understand that some of you, a few of you anyway, may pursue a career in law, so I urge the attorneys arguing today not to dissuade them from that ambition. Thank you, kids. I'd also like to point out that Justice Dougherty is participating remotely today, and he will be listening to your arguments, and he will be voting on the cases. Before we hear the first case, I'd like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their reply briefs for any briefs for any particular issues. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we're asking you questions. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that we do not permit rebuttal. While there is no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Lutheran Home and Keynes Human Safety Manor Estate versus the Department of Human Services, representing Lutheran Home, Mr. James Tierbuff, representing his department, Mr. Jonathan Patch.
Good morning. The federal government and the states jointly fund the Medical Assistance Program, which is a health care payment program for the poor, elderly, and disabled. Appellee, the Department of Human Services, administers and obtains funding for this program, including through the issuance of relevant regulations. Appellants are long-term skilled nursing facilities who provide care to medical assistance program-eligible residents. In this case, appellants challenge the relevant periods for calculating the annual payment rate known as the case mix rate, which includes an inflation factor that is computed pursuant to the department's relevant regulation and its interpretation of it. Historically, our courts have given deference to an administrative agency's interpretation of its own regulation, and in doing so have followed federal case law regarding the appropriate level of deference to give. The primary question on which we granted aliquotter is whether our court should adopt the updated requirement for our deference, A-U-E-R, our deference, set forth in the United States Supreme Court's 2019 decision in Kaiser v. Wilkie, or whether we should fashion a different standard. Please proceed.
Thank you. Good morning, Your Honors. May it please the Court, my name is Dan Tierbuff, and I represent the several long-term care skilled nursing facilities that are the appellants in this case. This case, as referenced by Your Honor, is fundamentally about beginnings, the beginning point of indexing or inflation of costs for the care and services provided to Medicaid residents of these facilities, which is the main issue on the merits, and also the beginning steps of the court's analysis of an agency's interpretation of its own regulations. Whether a reviewing court starts this analysis with deference to DHS interpretations of its regulations, unless that interpretation is plainly erroneous, as suggested by the Commonwealth Court, or deference, or whether the courts, as we suggest, begin at the first step of exhausting all tools of statutory construction, adopting the cabined deference as in Kaiser v. Wilkie, prior to a determination of genuine ambiguity and granting any deference to the agency's interpretation. We're requesting this court, in this case, to declare that deference to agency interpretations is not required, and approve the use of Kaiser protocol and the reasoning in Loper-Bright for finding the best meaning of a disputed term as consistent with the court's decisions on statutory construction.
Can I ask you, counsel, why you opted to advocate the majority standard in Kaiser, if we can call it that, rather than the Gorsuch concurrence? Or can I infer from that that you don't agree with Justice Gorsuch that the majority in Kaiser adopted a zombified deference?
Your Honor, to advocate for my clients, we believe that the majority's decision with respect to the cabining of our deference is sufficient to reach the questions at issue here. We would suggest that it is this court's prerogative to decide whether to further follow other areas of federal precedent, and we would suggest that the reasoning in Loper v. Bright be adopted.
Well, if you're I saw that. I saw you're advocating for the Loper-Bright reasoning. Don't you find that reasoning in tension with Justice Kagan's writing in Kaiser? Doesn't it dovetail more with Justice Gorsuch's writing in Kaiser?
I would agree with you, yes. But as mentioned in our brief, Northwestern Youth Services v. DPW, this court stated that the Pennsylvania's court treatments of deference to administrative agency rules and interpretations have always followed the lead of the U.S. Supreme Court.
But why should we defer to interpretations? I mean, it's one thing to, why aren't you questioning this deference in light of your favoring of Loper-Bright? Why aren't you questioning deference writ large? Why can't we reason and be persuaded and get rid of this whole deference superstructure?
I would agree that the whole deference superstructure should be abandoned at this point if you follow the lead of the Supreme Court of the United States. However, to get to our reasoning in this case, the cabined reasoning of Kaiser is sufficient. We can start the process with the analysis of the actual statutory toolkit, which in this case, we agree with the Commonwealth, is the Statutory Construction Act of Pennsylvania.
The problem with applying that, so it's interesting the U.S. Supreme Court refers to this idea of a genuine ambiguity. We don't have that terminology in statutory construction, either a statute is ambiguous or not. Your recapitulation of the Kaiser test would be apply all other tools of statutory construction, and only thereafter, if there remains an ambiguity, give deference to the agency interpretation. Is that your view of the test you want us to adopt?
Yes, Your Honor.
How is that not in tension with the Statutory Construction Act itself? Remember, the feds do not have a Statutory Construction Act. Their principles of statutory construction are based only on common law. Our Statutory Construction Act places an agency's interpretation on par with all of the other tools of statutory construction. So arguably, if we adopt Kaiser, we are violating the Statutory Construction Act.
Not necessarily. Kaiser suggests that we go through the process of exhausting the statutory toolkit.
Just so we're clear, Kaiser is not a statutory, the feds do not have a statutory toolkit. The feds have a common law toolkit.
That's correct, Your Honor. But if we examine the Statutory Construction Act, there are a number of considerations that we go through and a process we go through prior to getting to legislative and administrative interpretations of the statute.
But that's true under our statutory construction rules. The last thing we look at is the agency's interpretation. So I'm a little bit confused about what it is you think we currently do as opposed to what you want us to do. And then we only look to the interpretation for persuasive, for what it's worth. So I'm a little bit confused as to how it is that you want us to do something different. But maybe for me, you could help me out if we got to some concrete language that we're dealing with so that I know where we're jumping off for this hypothetical, theoretical question that we've accepted for review.
I would agree, Your Honor, and I would go to the merits of this case, and particularly the examination of the regulations at issue. agree that we can get to where we need to get through, going through the Statutory Construction Act process, and we agree with the Commonwealth to some degree that it is the text of the regulations at issue in this case. Our difference of opinion is that the language contained in the case that we're examining, the regulatory language, discusses how prices are indexed forward. That's the inflation process. And that process is, the state points to, the Commonwealth points to the language, and the department points to the language about cost report information. The operative language is, how do we index forward to an endpoint, which is, to the midpoint of the rate-setting year.
But there's precise language in the regulation, and just for clarity's sake, this went through the Commonwealth document law process, correct?
That's correct, Your Honor.
Okay.
There was no rulemaking on the final form regulation that was issued. There was no comment period on the final form regulation. There was a rulemaking process. There were no comments that were considered in the final form regulation that was issued. We don't have any way to look at any rulemaking support for this particular regulation.
But you're not challenging that it was improperly promulgated?
No, we're not challenging.
Okay.
So, if you go through the analysis of the operative language, considering the whole regulation, we submit that the Medicare Provider Reimbursement Manual, the methodology that's uncontested, that you would inflate costs from the midpoint to the midpoint, giving a full year of inflation for each cost report, is integrated into the regulations through 55 PA Code Section 1187.51. The Commonwealth Court below pointed to the language that in the regulation it states that it does not apply to subchapter E, which is allowable cost calculations. We submit that it also states that it applies to the entire chapter of 1187. So the operative section of this regulation is 1187.91.14, and that is in subchapter G, and therefore the Medicare Provider Reimbursement Manual, and its provisions with respect to indexing.
So, Counsel,
Why?
once again, I'm at a basic level here. The language of the regulation, prior to price setting, cost report information will be indexed forward to the 6-month of the 12-month period for which the prices are set. And that's what you're focused on?
Yes, and I'm focused particularly on the language. What we're focused on is, what does index forward mean? And we suggest, in fact, that the only interpretation, the only terms that are active here, that are applicable here, are the supplement information, because otherwise it's silent. What their proposed methodology from endpoint to midpoint, there's no basis for it.
Well, cost reports are filed on a fiscal year, right?
They can be filed on a fiscal year or annual year
Well,
basis.
filed on an annual basis if the annual basis is your fiscal year.
There are 1231 year-end cost reports and 630 year-end cost reports.
Okay, we won't dicker on that. Depending on your fiscal year, it's either 1231 or
Correct.
6.
Correct.
So if the cost report that is filed is on a 630 basis,
Right.
then that would be indexed forward 12 months. Because
It would be from the midpoint of that cost report year.
I'm not sure that's the department's position. I understand the department's position is they look at the data at the end of the cost report, whether it's calendar year or fiscal year, and at that end data is what they'll index 6 months forward. So they see, that seems to be their position. So it really is up to the facility to decide whether they want 6 months of data or 12 months of data. If they choose a 630 cost report as their end year, they'll get 12 months. But if they choose calendar year, they're only going to get 6.
I would agree that that's the department's position. I would state that our position is, it's undisputed that that if you choose the starting date at the midpoint of the rate year to where the end date is at the midpoint, the starting date of the midpoint of the cost reporting year to the midpoint of the rate year, you're giving a full effect to that 1 year's inflation. And it's undisputed that the department's method essentially shortchanges.
Well, it shortchanges the provider, it's the shortchanges the providers who use the calendar year.
Right.
It's that it doesn't shortchange providers that use the fiscal year. And
If
it seems to be within your client's control whether they get 12 months or 6 months.
If providers choose a 6/30 year end, it still would go back to the middle of that fiscal year, which would be essentially 12/31. So it's still an additional 6 months of cost report inflation.
I'm not sure I understand. The department's position is when this section that Justice Donahue is rightly directing you to, cost reporting information, that phrase.
Yes.
The department says that means the cost report that is filed annually and that data that is at the end of the cost report for that 12-month period, whatever it is. We take that number and we index it forward 6 months into the next year. That gives people who have if your end date is 6/30, you get 12 months. If your end date is 12/31, you only get the 6. And you said that is I'm correct in my understanding of the department's position.
You're correct with respect to the department's position, but if you use a 6/30 year-end cost report,
I mean, if you use a 6/30 year-end cost report.
if the provider uses a 6/30 year-end cost report, and we use it the way Medicare uses it, then you still get that additional 6 months.
No, I understand that. I understand that's what you're arguing. I'm asking why the department's interpretation is incorrect. If by saying, to me, this case is pretty dense.
Yeah.
To me, this case comes down to what does cost report information mean? And if cost report information means what you mean, which is just pick the number in the middle of the cost report, the 6-month period, not the end period, the 6-month period, for people that file on a calendar year basis, it yields one thing. The department's point is, no, we think cost report information means the annual cost information, whether it's 12/31 or 6/30. Why are they wrong?
They're wrong because their own regulations direct them to use the methodology that the Medicare program does, absent any other treatment. And they're wrong because if that regulation was what they said it was, it should have been drafted that way. It leaves it silent. And therefore, you can go to the Medicare Provider Reimbursement Manual as a supplement to that provision, and that's what the regulations say.
Could I just jump in?
Sure.
That's an interesting exchange you're having, and I wonder whether your larger point is that as between these interpretations, yours and your colleagues on the other side, that the ALJ, the BHA, the Commonwealth Court should have evaluated the arguments and the text on an equal footing and considered the expert testimony on an equal footing and made a judgment of law accordingly, rather than putting a finger on the scales with this deference overlay. Isn't that the larger point?
I would agree with you, Your Honor.
Isn't the point that we're courts of law, we're trying to apply law to facts, and that we're now in a world where we're questioning the need for this whole deference overlay. Isn't that the larger point?
Yes, Your Honor. To reference basically the approach that BHA and the Commonwealth Court took, they essentially looked at the text as they suggested of cost report information. The Commonwealth Court actually misquoted the provision applying the Medicare manual to the wrong subchapter. So in that instance, they looked at they looked at it and came to the conclusion, after going through that analysis, that there are two reasonable approaches to inflating costs forward, which we disagree with, and they decided in that instance to use deference to put their fingers, as you said, on the scales.
But let's say they didn't use deference. Let's put the language aside. Doesn't the statutory, in the face of an ambiguous statute, doesn't the Statutory Construction Act provide in the toolkit in the statute, 1 through whatever, for the court to consider, maybe not give weight to, but to at least consider the agency's interpretation? It doesn't say consider the other party's interpretation. It doesn't say consider every party's interpretation. We would do that. But the General Assembly has specifically instructed us to look at the agency's interpretation in resolving whether a statute, how to interpret an ambiguous statute. So let's say they didn't defer to it. Could they at least consider it? And the General Assembly seems to say, you have to give it some consideration, and why put it in the statute unless it was at least more than the other side's?
I would agree with you that, yes, it's the eighth provision of an eight provision list.
Yeah, but it's not necessarily a priority list. It's an eight items.
And what we're suggesting is we first go through the rest of the list.
Well, I know, but
especially the main text.
that's an interesting argument, because we have never, ever said that from a statutory construction perspective. That's 8 separate tools that a court can look at. You're asking us to say the 7 have to go first before the 8th. Is that now that becomes a statutory construction question of what the General Assembly meant in the Statutory Construction Act. So are you saying, what is your argument that the General Assembly meant us to go 1 first, then if it's still ambiguous, 2, then if it's still ambiguous, 3, and just go down the list until we come to a conclusion?
I wouldn't go that far, Your Honor, because it says in the statute, when the words of the statute are not explicit, the intention of the General Assembly may be ascertained by considering, among other matters, and then it provides the whole list. You could, because it's the last on the list, infer that it's the intention of the General Assembly to make it the last consideration, and I would encourage that.
Or it may be that it doesn't come up in every statutory construction context.
Correct. And we would suggest
More likely.
we may not even get there.
But maybe that we'd be considering, we would certainly expect the fact finder to consider the arguments of the parties, including the agencies, right?
Yes.
It would be error if we got a record where the court said, I did not consider one of the parties' arguments. Wouldn't
That's
it?
correct, Your Honor. Yes, absolutely. I agree with you. And in this case, we really don't see too much support for the actual interpretation. I mean, within the text, there really isn't. There is a textual argument that of our position, as I've said. There's really not. What is the wisdom with respect to the enabling statute of shortchanging at least a half set of providers half a year of inflation? There's looking at that and looking at the intention of the statute, looking at the allowable cost provisions, which are to reimburse providers for reasonable allowable costs when taking care of Medicaid recipients. I don't see any support for that interpretation, and I see a textual support for ours. And that could be the end of the analysis, even before we get to the 8 provisions of the statutory.
Well, you don't see the reason for it, but as Justice Robson and you discussed, cost report information is in the control of your clients. I mean, you're suggesting there's an ambiguity in that term, and I keep getting back to this. Is there an ambiguity? I mean, because if there's no ambiguity, we're done. So you're suggesting the ambiguity is in what terminology?
The ambiguity is in the phrase index forward.
Okay.
And the cost report information is not the operative term here to be interpreted. There's clearly an endpoint to the indexing, which is the midpoint of the rate setting
But
year.
it doesn't cost report information drive when the indexing forward takes place?
Allowable costs are an input. cost report information, but cost report information isn't even defined, actually, in the regulation. Allowable costs are the input, and allowable costs are the output of the process that goes forward with rate setting.
But cost report is, you know what the cost report is.
Yes,
It's,
absolutely.
Right. So doesn't cost report information mean information in the cost report?
It does.
So then the question is, can you just pick any point within that cost report? Or does cost report information mean the end point of that cost report?
The cost report information is in and of itself governed by the subchapter that determines allowable costs, but allowable costs carry forward to the provisions that we're discussing. They're the input.
You don't want to, let me try and get you back to cost report. We know what cost report is,
Yes.
right? We agree that that is that annual cost report that's filed either on a calendar year basis or a fiscal year basis, right?
Right.
So then the question is, what is cost report information, which is indexed forward by 6 months?
Cost report information is what's contained in the allowable cost. It's not.
In the cost report. You can't pull it
In
from
the
somewhere
cost
else. It has to come from the cost report, right?
That's true, Your Honor.
Which part of the cost report? Is that the ambiguity? Cost report information, there's a lot of information in the cost report and it doesn't tell you which, either the end number or the middle number. Is that the ambiguity?
Your Honor, I wouldn't suggest that we even need to approach the cost report information itself, because what we're discussing is how that cost report information is indexed forward.
Right. Well, we need to know what information is indexed forward.
It's not necessary to the question, respectfully, it's not necessary to the question at issue here. The whole section of allowable cost report information goes through a process of disallowing certain costs, adjusting certain costs. We go through that entire process in subchapter E till we get to the regulation that's at issue here, which is in
But when you go through
Chapter
that
G.
entire process, the end result is cost report information.
yes,
I
sir.
understand there's a process you have to go through, but then you get to this regulation, you've gone through that process, and so now you have come to cost report information. Correct?
Correct, Your Honor. And then you go through the process of setting prices, which ultimately result in rates and prices, and that input, again, that input is allowable costs. Those allowable costs, as a function of the allowable costs, are indexed forward from a point certain. And that point certain, as we suggest, should be the midpoint to midpoint. And we respectfully request that the department remand this matter for a calculation using the correct methodology, giving a full year of effect of these costs so that they're properly inflated and the providers are properly reimbursed.
All right, any other questions for Mr. Netterbo? Thank you, sir. Let's hear
Thank you.
from Mr. Koltesh.
Madam Chief Justice, and may it please the court, Jonathan Koltesh, along with my colleague Thomas Carr for the Commonwealth. This case at its core is about what role, if any, federal jurisprudence should play in Pennsylvania administrative law when addressing an agency's interpretation of its own regulation. It is the department's contention that federal law does not and should not play a role, and that this court should affirmatively state that. This court need not and should not rely on federal law. The canons of statutory construction provide sufficient tools to address this issue and issues like it in many agencies. If this court were to apply the federal principles to the concepts of deference, Chevron and Loper-Bright, its subsequent case Loper-Bright, are inapplicable here. The Auer deference is appropriate and not the plurality opinion in Kaiser. Turning to my first argument, that this court should not rely on federal law. This court set forth in Tire Jockey and Propotsky versus the PUC at Conglomerate, essentially amalgamated a series of case law into a two-part test in Tire Jockey that says courts, primarily Commonwealth Court and the administrative agencies, have to do two things: determine whether an interpretation of a regulation is erroneous or inconsistent with the regulation itself, and whether the regulation is consistent with the statute under which it was promulgated. This court noted in Tire Jockey and some of its progeny that Often, both parts of this test aren't applicable in the same case, and that holds true to this one. The second part of that tire jockey test deals with the promulgation of the regulation. I'm certain my colleague on the other side doesn't contest that the regulation was improperly promulgated.
Yeah, Mr. Koltash, I'm not sure why you're talking about tire jockey. This is not a tire jockey case. They're not challenging the regulation, they're just challenging your interpretation of it.
I think the first part of tire jockey, Your Honor, does deal with the regulation, and Commonwealth Court alluded to that, and that is to determine whether the interpretation of the regulation is erroneous or inconsistent with the regulation.
No, but that's I don't know. I didn't view this, maybe I'm wrong. I didn't view this as a tire jockey case. I viewed it as a statutory construction act.
Well, and I believe that first prong of tire jockey tells us to turn to the canons of statutory construction when you're dealing with an interpretation. And that is what we advocate that you do here. You turn to section 19, to the canons of statutory construction. The canons give us two steps. The first is to determine if a regulation is ambiguous. In this case, the department contends that there is a reading of this statute that is in fact not ambiguous.
And what is that reading?
That reading, Your Honor, so...
Get to the language one more time.
Yeah, I will, Your Honor, absolutely. The regulation says that prior to price setting, cost report information will be indexed forward to the 6th month of the 12-month period for which prices are set. The question really comes down to that starting point, the cost report information. The cost report is developed in section 1187.51. I believe it's subchapter E of this regulation. In that chapter, the scope provides for determining, so when you set the cost, you have to look at a large bucket of items that are incurred in these facilities and how they go into one of 4 categories of costs. What the regulations do say, and where I disagree with my colleague, is for subchapter E only, in the scope of subchapter E only, when the department is silent on how to characterize one of these costs, we turn to a sister program, the Medicare Guide. And only you turn to the Medicare Guide when it's not inconsistent with department regulation or guidance. Those costs then go in through that Chapter E process. There are a couple other subsequent chapters that intervene, and then we turn to 1191. That information is fed into what's called an NIS database. It's provided by the providers, it is audited, and sometimes litigated by the facilities, and ultimately that becomes the audited report. That is the total cost report information. The term's not defined, but even using the canons of statutory construction, you would use all of the tools provided by the General Assembly. That's the cost report, the audited cost report. Clearly, the information within the cost report is a word that we could pull as simplistically as from a dictionary. It's the materials in the audited cost report. We take that index, it's an end-of-year process, and we index it forward to the 6th month of the 12-month rate period.
Doesn't your cost indexing method exclude half the inflationary period?
For some facilities, it does, Your Honor. For some facilities, Your Honor. As Justice Robson pointed out, that is in the control of some of the facilities first. But more importantly, I remind the court that Medicaid does not guarantee full cost reimbursement. The purpose of the Medicaid reimbursement is to focus to ensure that the citizen who needs the care gets the care, not that the facility receives full cost. This court, Commonwealth Court, the Third Circuit, a number of the Third Circuit's sister courts have routinely said facilities aren't guaranteed full cost reimbursement.
So are you saying that you would be okay with the Medicaid approach?
No, the Medicaid approach, not the Medicare approach. The Medicare guide only applies to when we have that list of things that we have to put into those cost buckets. It's like a when in doubt, when there's no other way to determine if this cost goes in capital or if it goes in patient care, or if it goes over here, we'll use Medicare, but it's cabined to section 1187.51 in subchapter E.
Do you think that absent a deference overlay, your CPA's testimony would have been credited over the 2 experts presented by Lutheran Home?
I don't, Your Honor. I think to the ALJ found them genuine in their testimony. But the ALJ, when the ALJ looked at this, you have to kind of infer it a little bit, but the ALJ sort of applied the principles of statutory construction. The ALJ determined there was an ambiguity, as did Commonwealth Court. I think that's, the ALJ then turns to that testimony and essentially says, at best, their expert, and it's the sole extent to what their expert's testimony should be credited to, is to essentially establish an ambiguity. Once the ambiguity is established, we would turn to the canons of statutory construction and those 8 factors. I disagree with my colleague that 8 factors, that one is more important than the other. You would weigh all of those 8
And they're a toolkit, right? And the word is that we may consider, right?
Correct. You may consider it.
required.
It doesn't say that you must. There's an argument to be made. We can walk through all of them, that in this particular case, we would meet more than one of them anyways, but ultimately.
I'm sorry to interrupt, but just to clarify. So are you telling the court that, as of now, you'd be happy to litigate on an equal footing? You don't need deference. You don't need that finger on the scales. You're happy to have a fair fight, so to speak.
With one caveat to that is to the extent a party shows up with an expert, that party shows up to say, look, there's another read of this, and if that read is reasonable, that would establish ambiguity. Once you get to ambiguity, then the text of the canons of statutory construction should and must apply. So there is, at that base level, if the agency has shown up and said, this is our interpretation, that's, if you look at it as a scale of justice, that's a weight that goes on.
But I mean, the question I have on that is that, why? I mean, you've made reasonable arguments here, and it seems like we walk right up to the point of saying that we can trust our courts to find which arguments are most persuasive, the better view of the law. And I'm struggling to understand why and how this whole deference construct, this command me instead of persuade me, should kick in Pennsylvania law.
I would concur with you, Your Honor. I don't think that it should. That is the department's position. Just simply placed, the canons of statutory construction predate Chevron itself. The General Assembly set forth this analysis. It gave a role for the agency or the General Assembly if there's a legislative interpretation. It placed a role for
Wouldn't it be error for us not to give you a role? In other words, let's pretend the Statutory Construction Act wasn't there for a moment. Wouldn't it be reversible error if a record came up to us and it made clear that the fact finder disregarded the agency? We have to hear your arguments, right?
I agree, Your Honor. I absolutely agree. I think that's exactly what I'm advocating for here. I don't believe there's an ambiguity here. I think
I keep getting back to that point. I mean, I understand the importance of this overriding issue, but if we're all in agreement that cost report information is not an ambiguous term, then I don't know where the ambiguity is.
I concur with you, Your Honor. I think, I think based on that, the department would win in this case. It should win in this case.
Well, Mr. Koltash, so help me with the cost report. Is there a cost report in the record?
There's not, I'm fighting a head cold, so I apologize. I grabbed some water here, Your Honor. There's not, I don't believe the cost report itself is inside.
So we don't have an example of a cost report?
We don't, and it's a complex document, so just.
Does the cost report break down every month?
I believe it's quarterly, Your Honor. I would have to confirm. It does, but they do report, I believe it's quarterly that the facilities have to report. It does go into, I believe, a quarterly analysis.
So for someone that files an annual, on a calendar year basis, their cost report, there is 6-month data, there is 6-month information within the cost report.
I'm not positive on that. I think there may be, but I'm not 100%.
Well, that's where the ambiguity could potentially come into play, because the regulation doesn't say the annual data, the annual information as reported in the cost report. It says cost report information. There's a lot of information in the cost report, year end, and as you said, quarterly.
With one exception there. What it does say is that the cost report information is taken from the NIS database, and the NIS database is the total cost, the audited total cost report.
That's the annual data.
That's the annual data.
Okay.
So respectfully, I don't agree that you can look beyond the total, what's in that NIS database, 1187.91.
So you cannot see quarterly data on that database.
How it's reported versus how it's entered in the database, I believe, is different. No, we rely solely on the NIS database, and that's what 1187.91 says. So the cost report information is pulled from that database, and the total audited cost reports are in that database. My position is there is no ambiguity here.
So the way they could resolve this, and then I want to ask a quick Statutory Construction Act question. The way they could resolve this is to start filing on a fiscal year June 30th basis.
That'd be one way, Your Honor, yes.
Okay.
I believe that would resolve, at least for some facilities.
On the Statutory Construction Act question, our deference jurisprudence is all over the place. There's cases from this court and the Commonwealth Court that says deference, substantial deference, great deference. I mean, it's
Overriding?
overriding. I mean, I don't know about overriding deference, but
No deference?
no. I mean, it's all over the place.
With all due respect, I didn't understand overriding deference either, Justice Wecht.
That overriding's an inside joke from yesterday.
Oh, perfect.
Yeah.
There are all
It
kinds of
is,
terms here.
I guess what I'm trying to think is I'm wondering whether deference does have any role in when we have, it kind of arises out of the federal context, right? Because they don't have a statutory construction act. So the courts created that on the federal side, and we sort of kind of stumbled into it in the Commonwealth. When the General Assembly lists 8 things to consider, and it doesn't say the parties' positions, right? Of the 8, it only says the agency's interpretation. It doesn't say the part. I mean, obviously, you're going to consider everybody's interpretation.
Correct.
But the Statutory Construction Act specifically says, and the agency's interpretation.
Correct.
Do you view that as giving some kind of deference to the agency's interpretation because it's specifically identified by the General Assembly as something that we should consider? And again, I take Justice Wecht's point. We consider everybody's arguments. But the General Assembly went out of their way specifically to identify the Commonwealth or the agency's interpretation. Why did they do that?
I think for a couple reasons. And I hate the word deference because I think the federal jurisprudence muddles the term up. So I'm going to refer to it as little d deference. It's what I've been doing in many of my practices here. In Pennsylvania, that little d deference is there is a role for the agency. The agency is subject matter experts. They are
Not legal experts.
not legal experts, but they're subject matter experts. They are often, they deal with the stakeholders and the other experts in the community. That position has to be given some merit. But the General Assembly, in its infinite wisdom, decided that it was one of the factors that this court, it left the legal determination to this court, first to determine an ambiguity, and then if there was not an ambiguity. I think we all agree. I think even here today, we all agree that if the language of a statute or a language of a regulation is clear, that is sacrosanct. That is what governs. When there is ambiguity, no law, no regulation is ever perfectly written. I've not yet met one. Then we apply these 8 factors. You don't have to apply all of them. Some of them just don't exist in every case. It's a may, all right?
Sometimes they point in different directions too, right?
Sometimes they do, and then they're a balancing test, Your Honor. And that's the General Assembly left to the wisdom of the Commonwealth Court and ultimately the wisdom of this court to make that balance.
Sometimes the Superior Court.
And sometimes the Superior Court, no disrespect to the justices from the Superior Court, but occasionally the Superior Court, left to the wisdom with administrative law at least, this tool. And ironically enough, that is what Chevron and Loper Bright and Auer and Kaiser try to untangle in the federal jurisprudence.
Well, they may have tried, but I think they tangled further.
I think
in other words, you've admirably gone through a bunch of different factors and tools that can be used. So again, I just wonder why you would insist that we need an additional tool, if we can call it that, of deference.
I actually don't agree that we need an extra tool. I think the canons and the canons alone are sufficient here. I think the courts, not to disrespect the court I spend most of my time in front of in Commonwealth Court, need guidance that we need to stop looking at the federal jurisprudence, and that is fundamentally.
And if we do that, doesn't that require at least a remand to them or below them for an application of that revised standard? Because the Commonwealth Court talked about deference, right?
I don't believe it does. I think the Commonwealth Court ultimately reached the right conclusion for the wrong reasons, and I think that it's a legal discussion, it's a legal analysis that this court could do on its own. It's simply a statutory construction analysis. This court is well adept to do it without a remand. Looking at those factors, for instance, the occasion and the necessity for the statute, this is a federal-state program that works together. Looking at how this regulation comes into existence, first, it requires, often the Medicaid program is overlaid by a complex federal system, federal requirements that the state has no choice into. The state, opting into Medicaid, the state has to participate, comply with. They do so through a state plan which is approved by the federal government, and in Christchurch was litigated to the Third Circuit, which found that our regulations and our regulatory scheme and state plan met the federal requirements, specifically 30A of the Social Security Act. So the occasion and necessity of the statute, I think you could adjudicate here. Obviously, jumping right to the 8th factor, we've already given you our interpretation, which is a factor on that scale. I'm going to disregard that one.
About the consequences of a particular interpretation, and there was, I haven't seen too many statutory construction cases that rely on expert testimony. I thought that was interesting. If there's anybody I'm not going to defer to on statutory interpretation, it's an expert. But what about the consequences of your interpretation of your, assuming there's an ambiguity, the consequences of your interpretation such that the facilities who have made a business decision to report on a calendar year basis are treated inequitably from the ones that report on a fiscal year end June 30 basis?
First, it's a choice of the facility, Your Honor. So the consequence.
Well, there may be a good tax reason for them to do it.
And there may be, but I think the more important argument there is to remember that this is a cooperative federal program, all right? It does not guarantee. Section 30A of the Social Security Act specifically sets forth, and if you bear with me one moment, it requires that these costs be efficient, that the state plan provide a method and procedure to assure that payments are consistent with efficiency, economy, quality of care, and assure adequate access to providers. The Third Circuit, the Commonwealth Court, and I believe this court, it just might be the Commonwealth Court, has already recognized that costs must meet the needs to cover the resident, the patient, the constituent, not the facility. So the fact that the facility may be shortened. But you also have to look at the whole equation, and that there's a fourth process in this equation. The indexing up is only one part of this process. There's a fourth step, which is called the BAF, the Budget Adjustment Factor, which has also been litigated to the Third Circuit. And it says, at the end of the rate setting process, we have a constitutional provision in Pennsylvania that we can't pay that which is not appropriated by the General Assembly. So the BAF comes in and it reduces the rates to meet the appropriation. So even if you were to order this case back and say, recalculate every nursing home for these years, that BAF is going to trigger, and it's still going to cut those rates because money can't be spent that hasn't been allocated by the General Assembly. And so I think the consequences are going to be the same. They may get a higher rate in Part 3 and a lower rate ultimately in Part 4. So I don't know that the consequence is here. But I really push back on that, the consequence argument here, and that is federal courts have long recognized with the Medicaid program, there's no guarantee to full cost in this program.
No, I'm not sure they're arguing that there's a guarantee. I think what they're saying is for facility, under your interpretation, facilities that do a fiscal year have a higher number in Part 3, and facilities that happen to do a calendar year don't get the benefit of that much inflation data. I mean, I think that's just their argument.
I think it's just their argument. I don't think that invalidates. I don't think that the consequence, you're correct, I don't think there's a lot of statutory construction cases really in that prong, but the position here, I think, is you have to look at the department's interpretation and its effect here, and I think in light of this complex program, the reality is... Are you
saying you don't think that's the case, or you don't think that is dispositive or relevant?
I don't think that factor alone is dispositive. I do think that's their argument. I do think it's a factor here. I think some of the other factors... You
acknowledge that may be true.
It may be true. It may be true. I do think that they control some of that. But I think that the complexity of the federal program and the nature of just the equation itself and how it interplays with the federal, that's a minor factor in this case. I think there are stronger factors under the canons of statutory construction.
All right. Are there any other questions?
Did you want to finish your thought?
But I'll proffer, just to go back to Justice Donohue's point, I agree. I don't concur that I don't believe there's an ambiguity here. I think this can be resolved before.
Thank you.
Thank you.
Thank you.
All right. Thank you both. Very well argued.
Yes.
Mr. Minner, would you call the next case?
Erie, Free Pennsylvania Skill Games, Amusement devices, Appeal of Pennsylvania, representing the Commonwealth, Ms. Susan Frunke, representing the Ellie's, Mr. Matthew Haverstick.
An electronic skill game machine that allows a player to deposit money and play a game of chance to earn prize money. Then, if the player loses that game, they may recoup the amount of their monetary loss by playing a second game in which the player attempts to memorize and repeat a sequential pattern of colored circles in order to earn a monetary prize worth 105% of the amount of their wager on the chance game. We are asked to determine whether such a game constitutes an illegal slot machine or gambling device under the Crimes Code. In answering this question, we are also asked to determine whether the statutes governing slot machines in the Gaming Act should be read in pari materia with the Crimes Code to augment the definition of slot machine in the Crimes Code. Please proceed.
Good morning, Your Honors. May it please the Court. My name is Sue Affronti. I am here to represent the Commonwealth in this matter. When it comes to gambling, this Court has been very clear. Gambling is the hope of gaining something beyond the amount played, and that's what creates the dangers associated with gambling.
Could you pull the microphone a little
Absolutely,
closer?
Your Honor.
Thank you.
Sorry, thank you.
That's all right.
Time and
You aren't
again,
quite as tall as the last
it's a
county.
problem, yes. Time and again, this Court has indicated that a single feature viewed in isolation cannot change the overall device. And that's what we are dealing with here today. What my opponent has in mind is something different than the predominant factor test. What he's talking about is an any skill test. And under the standard adopted by the Commonwealth Court, if a game has any skill component, that's enough. But that's not the law, and that's not what this Court explained in two electronic poker game machines. There, the Court said it's not enough that the outcome of a poker game could be impacted by skill. It must be shown that the skill is a predominant aspect of the game. I think I'd like to focus a little bit right off the bat about how gameplay appears on this device. I think that would be most helpful. 63% of the time, when the reels stop, so the game begins with a game of spinning reels. When the reels stop, 63% of the time, there's no possible match. When that happens, the reels stop and the play button immediately illuminates. At that point, the player can hit play again, a new wager will be placed, no skill element will be looked at, and the game starts over. My opponent admits this happens, but says that's fine, and it doesn't matter, because the player chooses to skip the skill element in the game.
Ms.
And that-
Affronti, can I
yes,
just ask a
absolutely.
follow-up question on that point?
Yeah.
Was there any facts in the record to indicate how often that occurs?
Yes, the expert's report, POM's expert report, goes through each of the three possible outcomes. The expert report, which is found at page, in the reproduced record, it is page 750. It's in our brief. It's the expert's report. There were three possible outcomes. Full winner, 8% of the time. No possible three-in-the-row match, 63% of the time. Partial win, meaning you get back part of your wager, 29% of the time. So the circumstance I was speaking of earlier was when 63% of the time the reels spin, play stops, play button illuminates immediately, no mention of follow me at all then. The play button illuminates, you press it, you move on. That's okay, says my opponent, because you choose to move on. You choose to skip follow me. But importantly, there's no discussion of follow me in the instructions at all. When the player presses play, they know about the spinning reels. That's all they know. And they also know that that play button illuminated again. If they sit there and stare at the game for longer than the 3 seconds that the game took in the first place, eventually, after multiple seconds, longer than the game, it will say at the bottom merely, touch here to follow me. That's the first time there's any mention of the skill component. And that's the only mention, touch here to follow me. It's not explained. I truthfully don't know why anyone would touch it. It's not telling you, press this button to use skill. There's no suggestion that that's the skill element. There's no suggestion that's a way to win your money back. The only way you discover that is if you, for some reason, touch there, and then, and only then, is the skill game explained. That's not a choice. So when the whole record here, there's many questions in the transcript. Is follow me available? And all the witnesses said it is, and it is available. But that's what they mean when they say it's available. It's only available if you press something that says touch here to follow me, and at that point, you get an explanation of what follow me is, only at that point. It is our position that that's not a choice, that it's available only in the most technical sense, and it is not enough for that component of the game to be deemed predominant. So also we talked about there's an 8% option where you win more than you bet. If that were to happen, then follow me isn't available at all. So 8% of the time, you play the game of the spinning reels, which looks just like a slot machine, and that's all you have. You only have the slot machine aspect of the game. And then the remaining 29% of the time, it's very similar, slightly different. The reels stop. There's no play button eliminated right away because you are supposed to place a wild now to make your 3 in a row. The game makes that different, right? The game of the spinning reels continues, so no play button yet. In fact, if you press the play button, there's a chime that tells you, we're not done.
Can I
Sure,
interrupt
absolutely.
you and just ask a question? It
Please.
seems to me that instead of really arguing an issue of law before us, you're arguing an issue of fact. So I'm going to read this line from the trial court, who is the fact finder in this case, and let you tell me how we then get to where you are with your argument. It says, more importantly to our decision, all of the witnesses who testified, including the Commonwealth's expert witnesses, agreed that a patient and skillful player could win at least 105% of the amount played on each and every play by utilizing the follow me feature.
Right, I agree completely, you can. That's why we get back to the word choice. This is about applying the predominant factor test. There's no factual disputes in this case at all. The game simply is what it is. It's an objective game. The trial court was able to see it. I think we've all had the chance to explain it. When you look at the two briefs side by side, there's no difference in gameplay. Gameplay is the same. What we're asking you to do is apply the predominant factor test. And I would point out, this is not uncommon in gambling cases. This court reversed the lower court and the mid-level appellate court into electronic poker game machines because it misapplied the legal standard. Same thing happened in Irwin, where this court reversed both the lower court and the mid-level appellate court, and the same thing happened in Dent. So Dent was a superior court opinion, but they were reversing the lower court. We're talking completely about facts that are not in dispute, and we're applying them to a legal standard. That's what we're talking about here.
All right, so the trial court continues that the Commonwealth did not provide sufficient evidence to support a finding that the majority of players do not play the follow me feature.
Right. So, Your Honor, again, I think the trial court applied the wrong standard. The trial court was saying, well, we expected the Commonwealth to bring in individuals to talk about their individual gameplay, or have our officers come in and talk about what they'd seen in the field. What we're dealing with here is an objective standard. It's an objective standard. It always has been. We're not talking about taking a poll. We're not talking about bringing in 100,000 people. In fact, the trial court's opinion talks a little bit about that, about the impossibility of assessing how every player plays. What we're asking you to do is to simply look at the objective game and apply the objective standard. That's what we've always done in gambling cases. So I don't think that's an insurmountable obstacle here, Your Honor.
Counsel, is it permissible to give an individual the opportunity to gamble?
Your Honor, I think that's a very good question.
Well, I think it permeates this.
It does, absolutely. And I think that when you look at what the legislature was trying to enact with the Gaming Act, and when they legalized gambling, The idea was to get away from that and to make sure
What was always illegal.
it's always been illegal, and I think we've just gotten more and more into that concept. And this game speaks to that entirely, right? What is this game predominantly about? Is it about playing Follow Me for an hour to win $1, or is it about the hope of spinning those reels 3 seconds and getting $2,000? That's the gambling, and that is definitely predominant here. I'm not sure I addressed your question, Your Honor.
Well, no, you have. I mean, in a way, it's difficult to shoehorn it into the predominant, not predominant factor. But just on the face of what's happening here, someone could walk into an establishment and gamble if they want to.
Absolutely.
They could walk into an establishment and never intend to play Follow Me.
Yes.
Just continue to put money into the machine and pull it and pull it and pull it or press it, however it actually works, with the hope that their gamble will pay off and they will hit the jackpot.
Yes, I think that's why predominant is what we're really talking about. What is the game really about? This isn't a game of whack-a-mole. This isn't a game of skee-ball. This is a slot machine, which perhaps makes it simpler to point just directly at 5513 and the language.
So why are you asking us to apply this predominant?
Right.
Why don't we just apply the statutes?
Yep.
I mean, didn't the General Assembly tell us exactly what to do here? In the Crimes Code, they specifically referenced the Gaming Act.
They do.
In E1-4 relating to amusements. And when we go there, we see a skill slot machine, hybrid slot machine, and the devices or associated equipment necessary. Why isn't that this case? And it's over. They're out of bounds.
I think it can be, Your Honor. I
Isn't it
think it
that
can be
simple?
just that simple, yes. You can write an opinion that says this is a slot machine. It's clearly a slot machine.
I mean, it's criminal activity, isn't it?
It is criminal activity under 5513. You need not go any further. You ask why? Because, Your Honor, we're prosecutors. We want to give you a couple options. So if you say to us, what about this, what about this? I'm giving you two choices. You can pick. You don't have to do both.
The problem with your Gaming Act position, though, is the default is gambling is illegal in the Commonwealth.
Correct.
And what the Gaming Act said, gambling is still illegal in the Commonwealth, except this gambling that we're going to regulate through the Pennsylvania Gaming Control Board. And the gambling that they're regulating in the Pennsylvania Gaming Control Board is slot machine as defined by the Gaming Control Act. That legal slot machine under that definition is one that is approved for use in Pennsylvania by the Gaming Control Board.
Yes.
Nobody's disputing these machines are not approved for use. So they don't meet the definition of slot machine in the Gaming Act.
That would...
Because if it did meet the definition of slot machine in the Gaming Act, it would be regulated under the Gaming Act and would be used in casinos in the Gaming Act.
I would disagree that phrase approved by the board is necessary for the definition of a slot machine.
It's in the definition.
It is, but there's a lot of words in the definition, Your Honor. I think the definition can be easily read, any computerized contrivance which, upon the insertion of consideration, any consideration whatsoever, is available to play, whether by reason of skill or application of the element of chance or both. Yes, I skipped words there.
skipped words.
But I didn't, of course I did. It's a very long, a very long definition. But I don't
But I
think
guess
I
my
took
point
out
is
any meaning there. I
That
think that it can be
definition,
read
the
that
reason
way.
why the General Assembly includes the definition of slot machine in the Gaming Act is because slot machine the term is used throughout the Gaming Act when it comes to licenses for licenses for companies that can sell slot machines to casinos, licensed casinos, how they have to be calculated, calibrated, their payouts, everything like that. Everything about the Act springs from the concept that these are approved slot machines. I don't know why we have to look to that definition. If these are otherwise slot machines that are not approved by the Gaming Control Board, then they're illegal.
Right.
We don't have to look to the definition of slot machines in the Gaming Act. If they are otherwise slot machines, not approved for use in Pennsylvania casinos, they're illegal.
I think I agree with you, Your Honor. I think it can be that simple as well. I like the idea of making this simple. I don't have any problem with that.
Anything else?
Your Honor, I would merely say predominance must be a real objective test that requires an evaluation of the entire game. I ask you to reverse the Commonwealth Court.
All right, thank you very much. Let's hear from Mr. Haverstick.
Madam Chief Justice, Your Honors, may it please the Court, my name is Matt Haverstick, and I represent Capital Vending. With me is Mr. Chris Carasone, who represents Champions Bar.
And Mr. Haverstick, you are tall. Could you raise the mic?
I'm happy to.
Thank you.
Well, Commonwealth, there you go again. You know, that was a funny line in 1980, but it really masks something a lot more serious, and that is government is not being honest. Government has not been honest in the way it's conducted this case from the outset. Judge Dowling saw it at the trial court. He held that the witnesses were biased in holding against them on every fact issue. The Commonwealth played fast and loose in Commonwealth court, and counsel was actually, I think, slightly dressed down in the opinion for not citing relevant authorities. This court penalized the Commonwealth for a brief loaded with facts that were not of record, that were facts that the Commonwealth, and I say facts sarcastically, that the Commonwealth tried to get into the record at the trial court and could not, and instructed the Commonwealth to redo its brief, and it still, in the next brief and today, comes into this court and tries to peddle to you facts that aren't facts. The facts are the record, and when you look at our brief and compare it to the Commonwealth's brief, the one thing you will see of significant difference is how many record sites there are in our brief and how few there are in the Commonwealth's brief. And if we had someone live streaming this today who had the ability to point to record sites for everything that I'm about to tell you and everything that the Commonwealth told you, we'd see the exact same thing. The Commonwealth has a credibility problem, and it has not gone away today. I'm hopeful I can answer actual record fact questions for you today in a straightforward way that I know will be backstopped with the record. But the Commonwealth can't even be straight with you about what test it was. I mean, first it says that, oh, well, the judge in Dauphin County was looking for evidence of how people played the game. That's not true. They tried to put the evidence in because they think it's relevant to their case, and the Commonwealth copped to that later in the argument, if you caught it, that, oh, you got to look at how people play the game. The fact is, they tried to do it. That evidence was excluded, and the court specifically at the trial level rejected the idea that gameplay, in this context, and how people are objectively or subjectively looking at the game is a manageable standard for determining whether the conduct is illegal under the Crimes Code. The objective test is, as the Commonwealth admits, the predominant factor test. And that test, since 1983, and we can presume legislative acquiescence to it, since the Crimes Code has been amended and 5311 has been amended multiple times since 1983 and never changed its definition. The predominant factor test, when you're looking at the skill versus chance, looks at whether chance has the ability to prevent a skillful player from winning the game.
So do you agree then, Mr. Haverstick, if we simply apply the definition of slot machine from the Gaming Act, which is cross-referenced in the Crimes Code, to the term slot machine in the Crimes Code, you're done? You agree?
I don't, and I think...
Why don't we talk about the statute? Why don't we put the predominant factor judicial construct over here and actually talk about the laws the legislature passed?
Sure, let's. So I think we can start by looking at 5513, and we know, and it's cited in the briefs, that, Your Honor, there have been multiple explicit efforts to amend either 5311 or Section 1301, the definitions in Title IV, to cross-reference slot machine definitions in both statutes. They've all failed. The other thing we know about the legislative history and what the legislature has done is that the legislature all the time cross-references definitions in 1301 with other statutory sections. It did it in Act 42 in 2017. It specifically, it went out of its way to cross-reference the definition of slot machine from 1301 in the section in Title IV that was dealing with VGTs. So if the General Assembly plainly knows how to assign the definition of slot machine somewhere else in the Crimes Code, in Title 18, in Title IV, anywhere else, and it hasn't done that. In fact, that same year, about 3 or 4 months before Act 42, which is the amendment to Title IV that added in VGTs and had the express adoption of the slot machine definition from 1103, General Assembly, like in late June of that year, amended 5513 and Title IV at the same time to conform definitions inside those statutes. So the General Assembly, we know, knows how to incorporate the definition of slot machine anywhere else it wants in legislation.
Let's talk about the actual words of the statute.
Sure.
So E14 is the cross-reference to the Gaming Act. In subsection E14 refers us to the Gaming Act. Then we look at the Gaming Act, and in the definitions, we have hybrid slot machine, skill slot machine, and your argument here is that you are somehow not within the definition of any of that. And that's really a breathtaking proposition. What more would they have had to say to bring your games within these categories?
Well, perhaps, Your Honor, it's what more would they have had to say and what shouldn't they have said. And what they said in the definition of slot machine, which carries over into the definition of skill and hybrid slot machine, is that a slot machine under Title IV has to be board approved. And look, I don't think it's a serious argument to say that we can pick and choose language in a statute that we're just going to edit out and pretend like it isn't there. That language is there for a reason, and a really important reason, because that language guarantees that the devices being discussed in Title IV as slot machines are truly gambling devices.
Well, no, it does more than that. That E1 saves four types of gambling that are legal under other laws from criminal violations. The state, because the state, if this exception in E1 wasn't in there, the lottery would be illegal gambling.
So would small games of chance.
So would small games of chance, so would bingo, and so would legal gambling under the Gaming Act.
So would, just yesterday, in the relevant Senate committee that handles gambling, there was a bill introduced to add some regulations to electronic pull tab machines. I mean, those are purely gambling devices. Nobody questions it. They also, Your Honor, meet the definition if you take out, well, actually, if you keep the right language. That machine has the definition that matches up exactly with the definition of slot machine in 1103, but nobody in the General Assembly yesterday or drafting that bill suggested that they needed to do something in Title IV. It's understood before and after that an e-pull tab machine, notwithstanding the fact that it meets the definition of 1103, is not controlled by Title IV. It's this other thing that's controlled by other parts of statutory law for gambling or regulating gambling in common law, specifically the Small Games Chance Act.
I still don't understand it. Even assuming we were to arguendo, that we were to accept your position that your games have any skill to them, which is a whole nother rabbit hole we could go down. This definition of skill slot machine, we didn't make it up. The General Assembly put it in the law, a slot machine in which the skill of the player, rather than the element of chance, is the predominant factor in affecting the outcome of the game. They were saying this is within this whole gaming structure we're creating, and yet you think you're in some other universe.
No, Your Honor. I think I'm in the evidence, or I'm sorry, I think I'm in the universe of what the evidentiary record showed here. And I don't want to harp on it, but it's important because I think it answers your question in a way that I hope helps you understand that what the General Assembly intended to do in that section, with the language we have to include and credit, was to regulate gambling devices. Now, the record, as we know, because it was admitted by their witnesses, and our witness testified to it too, has the game in question being winnable on every play for 105%. That's, that's not challenged by anybody. That is a part of the record. They didn't appeal it. They didn't bring an abuse of discretion appeal. They've admitted they're stuck with that fact. They don't like it, so they talk about other stuff, but they're stuck with it. The other testimony that is unchallenged on appeal is the testimony of our expert who testified that winning percentage of 105% means that the game's return to player is always going to be over 100. It cannot mathematically be under 100, and frankly, it can mathematically go a lot lower than 85%, all the way down to like 6 or 10%. Why does 85 and 100 matter? In the definitions section, I'm sorry, it's not in the definition section, it's in the board power section of Title IV, 1207, the board is instructed and required to set regs that control the guidelines and guardrails for what a gambling slot machine may or may not pay out. And it says in the statute that a minimum has to be 85%. Well, our expert testified, unchallenged, that our minimum is well below 85%. But here's the critical piece. When you look at the regs, the Gaming Control Board sets what a slot machine, whether it's a skilled slot machine, a hybrid slot machine, or any other slot machine defined in Title IV, has to pay out. And that game over time cannot pay out and cannot have a return to player percentage equal to or higher than 100%. It also cannot have a return to player percentage lower than 85%. By definition and mathematics and the unchallenged testimony from the trial court record, the pay-somatic game falls outside on both ends of that definition. It can never be a game, a slot machine rather, as defined under that statute. And you know, they're not here, and I can't call them because they're not witnesses, but I can tell you that the Gaming Control Board believes the exact same thing. It knows that because that game is winnable on every single play for more than the consideration you put in, it is outside of the regulations that the Gaming Control Board says a game must have to be a legal slot machine in a casino or in the casino.
What did they mean by skill slot machine then?
Well,
What, like, I guess put it differently. So we have slot machines, we have skill slot machines that the legislature talked about, we have hybrid slot machines the legislature talked about, and then we have whatever it is you think you have.
Well,
so that's some total other category. What is this other thing then?
well, I'll tell you what. Look, I guess we're allowed to go outside the record, so I'll tell you if we put the Gaming Control Board folks up here in truth serum, they would tell you what I'm about to tell you. And in the mid part of last decade, it became clear that the standard slot machine in casinos was not as popular with a younger crowd. They wanted games that were interactive, like arcade games on top of slot machines. So the slot industry came up with what became known in Vegas and now got incorporated into Pennsylvania right around the same time, is a skill or a hybrid slot machine. That game still has to have, according to our regs and to the industry, a return to player that is less than 100. That's why it stays gambling. The house always wins.
No, that's why it stays regulated gaming. That's because you're mixing the definition with the substantive provisions of the Act. The reason why the Act defines a slot machine is because it was limiting and regulating who can manufacture them, who can sell them, and what standards they have to meet for payout in casinos. But let's put the statutory definition away. Aren't these slot machines?
No.
Why not?
And that's exactly my point, Your Honor. I wanted to answer the question from the Justice about what a skill slot machine actually is in the industry,
Not based on the regulation and how the General Assembly is defined it for purposes of what kind of machine can be put in a casino.
But answering your question is exactly the point I want to make. What the General Assembly did with Title IV was make this little bottle universe where you can have legalized gambling. Otherwise, gambling
It's illegal.
is illegal. And the test that this court has applied for gambling since before 1983, all the way back to the Penal Code of 1939, and actually before that, is a variant of the predominant factor test.
Well, that's, yeah, so basically, let's see here. The Gaming Act, according to you in the Commonwealth Court, is concerned with licensed entities.
Yes.
And licensed facilities, and has absolutely nothing to say about unlicensed activity. And if that argument prevails, it has some startling implications, because we could take any kind of generic licensed activity. Let's take hunting, for example, so that licensing only applies to licensed activity and doesn't regulate unlicensed activity. And so anybody can just pick up a gun anytime and go hunting anywhere, anytime, because it's not licensed, it's not regulated. And I mean, we could take other examples, fishing or anything. All you have to do is say, I'm not within the regulation, I'm not licensed, and therefore I'm not within your statutory regime.
No, Your Honor, and this case is a perfect example of what we're talking about. Gambling was illegal before Title IV. Outside of the little bottle universe where legalized gambling can exist, and that includes the lottery and that includes small games chance, gambling still is as illegal as it was before Title IV. So in a licensing structure, you're being given limited permission to otherwise not comply with, in this case, the Crimes Code. But that doesn't mean the Crimes Code goes away. It just means if I'm outside of the bottle universe where gambling is allowed in a casino, and I'm gambling as defined by 5513 and this court, further Electrosport and its progeny, well, then I am regulated. I'm regulated by the Crimes Code. This is not all a parade of horribles about, we're going to allow for explosive illegal gambling are a non sequitur. You still can't gamble illegally outside of a casino.
Well, that's the question: is your machine gambling? And I'm going to ask you two questions, which I really don't think are disputed. Can you play these machines without playing the chance side?
Yeah, well, of course. I mean, yes. Of course.
How do you get directly to the skill side?
Well, before you put the money in, you can see. And Your Honor, I want to answer I want to get back to answering your question about the play, because you didn't get an accurate answer, and I'll give you one about it. But before you put your money in, you can use the preview feature and see what the game is going to do on every single iteration of what comes next. Every wager level.
No, I thought maybe you're answering my question, but I don't think you are. Can I walk into one of these places, go to that machine and say, I don't want to play the chance side. I don't want the spinning this and all that. I just want to go right to follow me. Can I do that?
Well, you're asking two different questions.
No, I'm asking one question.
The question you're asking is,
can I play the machine
and go
without playing the chance part?
Well, I'd say no. I mean,
okay, good. Okay, let's stop there. Let's stop there. Hold on for a second. Can I play the machine without playing the skill side?
Yes. Yes. I mean, it's not amenable to an easy yes or no answer, but I'm just saying
Why is
yes.
it not amenable to an easy yes or no answer?
Because you're ignoring what the game does.
No, I'm not. I'm just asking. I'm asking you a basic question. Can I walk into a parlor and only play the skill side?
You can walk into a parlor. You can put the money in. You cannot do the preview feature. You can press play and see what happens.
No, I'm not asking about see what happens. Can I
go
right to the skill side?
That's what I mean. You have to play through the tic-tac-toe puzzle to get it.
Correct. You can't just skip it.
No, you have to either play through or deliberately. Yeah.
But I can ignore the skill side.
The tic-tac-toe puzzle pops up first. When you put the money in, the first thing that happens other than you can, before you put the money in, look at the preview feature and see what's gonna happen. Let's say you skip that. To your example, you put the money in, the first thing you do is press play, the tic-tac-toe thing happens.
Yeah, I can't ignore it. I can't avoid it.
No.
I have to play it.
And so what happens?
I have to risk my money on it.
Well,
I have to.
I'm not sure it's a risk, but you have to play that section of the game first.
It's a risk because I don't have any control over it.
Well, define control. You do have control over it in that before you put your money in, you could see what the game was going to do. You don't have to play the game and put your money in to see what's going to happen when you press play. You see it ahead of time.
Wait, I can actually see the result?
Yes.
Well,
Yes.
wait, I can actually walk into, this is interesting.
Yes.
This sounds like a great money return. I can walk into one of these places, press it, see if I'm going to win the next play, put my money in, and it comes up exactly as I saw it in the preview.
Yes, and that's why our expert testified he doesn't even think chance in the opening game is a predominant factor because that feature largely eliminates chance.
How do you make money off of these things?
Because, look,
I mean, if I'm going in and I can see, I'm just going to walk away if the next screen doesn't give me a win.
well, right, and you can, and that's why it's a skill game. Look, why does it make money? Because somebody really brilliant came up with an idea that they tested in the Beaver County case, and it was held to be legal and nobody appealed, and they made it creative and fun that depending on the environment you're in, you can either win it every time, guaranteed, and make money, or you can have fun. I mean, in the same reason, but it's true.
The base spin generates a win or a loss, right? Can't you just candidly answer that it's going to generate a win? They're going to spin, and it's going to generate a win or a loss, and then you can either press for another base play, or you can do this follow me thing if you happen to see it.
No, well, first of all,
Isn't that right?
the court, yes, but the court held that you do so. Remember, the gameplay was demonstrated to the trial judge. They went over follow me multiple times.
It's available to us, and I've seen it. It's in our record.
If you make more, again, I'm not trying to hedge in your question, but the terminology again is, I mean, you got to be particular about what a win is. There's a win that's over 105%, and in that case, Your Honor, you don't get to play follow me. If you win more than 105% of what you put in the game from the jump, you don't play follow me because you've already won.
The maximum is $4, right? And so $4.20 is your max, right? But you can't get paid except in increments of $1. So you win $4.20, it's just illusory, right?
No,
You have to play again.
well, have you lost it? Of course not. And have you lost, in fact, have you lost anything? If you left the game, if you won $4.20, well, let me answer your question about the hit and the win. The second win is a win that's 105% or less. And in that case, you are always, 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 always permitted to play follow me. It is there, it is visible, the trial court found it to be visible, it is there to play, and every witness admitted if you play that, meaning if you haven't won as much as 105%, you are always able to play follow me, and if you are skillful, you will always win follow me. The loss is what you're talking about, where you don't get any winner, and that also provides follow me for you to play. Your Honor, have you lost the 20 cents in your example? It's still there for you to play. You can play it. It didn't get taken away from you. And in fact, if you decide to walk away from the game and leave it on the machine, you haven't lost anything. If you put $4 in, won $4.20 after you played follow me, and cashed out because you're annoyed that you can't get the 20 cents, you haven't lost anything.
I'm trying to make this so I can actually understand it. And I know that's hard for me, but I looked at it this way. If a machine has two components, one chance, one skill, and every player has to play the chance, but not every player has to play the skill, then chance is the predominant factor and it's a gambling device. Why am I wrong?
Because, and I thought a long time about a really common sense definition of how you define what a predominant factor is. And this is the one I came up with. It's borne out by the case law, and it also makes common sense. I think a game passes the predominant factor test if, notwithstanding any element of chance, you can win it every time. And not sections of the game, because that's not how game cycles are determined.
Why is that a better test than what I'm saying?
Yeah.
Because in my example, your skill overrides any element of chance. Chance, in the Pace-O-Matic game, chance can never prevent me from getting at least 105% of what I put in.
So, Mr. Haverford, let me stop you there. In answer to Justice Brobson's question, why didn't the designers put the skill game component first and make you win the skill game before you get to the chance? Because if the predominant factor test is what Justice Brobson's alluding to, why wouldn't you just put the skill game up front, make the player go through the skill game process, win it, to get to the game of chance? Because to me, that would be the predominant factor. It's a skill game to get to the chance. But the designers of this particular manufacturing machine make you go through the chance game first to get to the skill game. So what's the predominant factor? If we ignore the statute, as Justice Weck has already articulated and Justice Brobson asked you about, and apply your test on the predominant factor, why didn't they put the skill game first?
Well, I think there is skill first, Your Honor, and that's the preview feature.
What's skillful about a preview feature?
You have to quickly match up on every possibility of what can happen next, whether you're going to get a winner or a loser, and then decide which one of the winners you want. Whether it's skill, and I think there is skill to it, is probably not as much of a point as the fact that it eliminates any chance. I mean, there is no chance about you go into that game knowing exactly what it is going to do if you decide to put money into it. No question about it, and that's in the record, and it's, again, they didn't bring an abuse of discretion appeal, so they know it. I mean, their people demonstrated it and testified to it. You know with 100% certainty and visibility what that game is going to do before you put money into it.
But that's not chance or skill. That's just, you're telling me you can just look at it and determine it.
Well, it eliminates chance.
What's the skill-based factor of it? We focus now, and I think the lower courts, the trial courts, and both the Commonwealth Court, focused on the skill component almost exclusively on the predominant factor because those were the issues that were argued. My question to you is, if your argument is correct and this is predominantly a game of skill, why aren't we playing skill first to get to the actual game of chance at the end? Well, they flipped it around. You got to play the game of chance first.
Your Honor, I don't think that they did. I mean, first of all, the answer that Judge Dowling came up with about the why is, well, it wanted to be compliant with the law, and it was. It was compliant with what.
I'm not suggesting it's not compliant with the law for a second.
Pardon me?
I'm just asking you about the predominant. You're arguing predominant factor. Justice Weck, Justice Brobson have argued to focus on the statute, and you're trying to change our focus to the predominant factor test. My question to you is, as a follow-up to Justice Brobson's, you're suggesting that it's a game of skill. My point to you is, why isn't the skill component first?
Well, look, the why sounds like a record question, so if you're asking why the designers did it, I imagine because they wanted to have a game that was legal and that also could make money. But it is not just it's not just the...
You said they can win 100% of the time.
105% of the time.
So if that's the case in skill-based and a skilled player can win 100% of the time, they're not going to make any money, right?
Well, I think they are banking on the fact that some people will choose to play it the way where you can win 100%, 5% of the time.
Component.
Pardon me?
Or they're banking on the fact that people just don't play the skill game.
Well, yeah, I mean, they could be.
What's the predominant factor? Is it gambling or skill?
It's skill, and, again, it gets back to what the law in Pennsylvania has been for decades and decades and decades. And I'm not talking just about electrosport. The new Ken case, which is a couple of years before the first 1983 skill case and was cited by Electrosport, I think, favorably, was a game where it was exactly set up like the Pace-O-Matic game, where there was a little chance game in the beginning, but then to win anything, to actually win anything, you had to play the skill pinball game. So this is not a new or novel construct.
Mr. Haverstick, you're telling me today that there is no chance aspect of this game.
No, I don't think I'm saying that.
You are. You're saying chance is risk, right?
Yes.
You're saying that the person who walks into this machine is taking no risk because before they put money in, they press the button and they know exactly how it's going to result. That's not even gambling. That's not risk at all.
Your Honor, look, that's what it's in the record. That's why I wonder sometimes why the Commonwealth is having this.
I mean, it's actually stupidity, right? I mean, if I walk in and I press a button and I know I'm going to lose, why don't I walk away?
Don't play our game.
What is gambling?
I mean, no, I'm serious. I don't want you playing the game because you've already figured out how to.
Counsel, is it legal to give people the opportunity to gamble?
I don't.
Because that's what is happening here. And that's why I am sort of loath to try to shoehorn this into any kind of test or the Gaming Act or anything of that nature. As I understand this game, someone can walk into a parlor, put in money, lose, put in more money, lose, put in more money, all with the hope that they'll hit the big jackpot. And your machines give them the opportunity to gamble. Is that legal in Pennsylvania?
Yes, it is, and it's the reason we have an objective test and not a subjective test to determine whether a device is a gambling
When
device.
is any gambling legal in Pennsylvania, outside of the context of the Gaming Act?
Well, and you mean small games of chance and the lottery.
Yeah.
Your Honor, think of it like a pool table. There are multiple ways you could go play pool. I could go shoot pool by myself and work on my skills. I could also go play pool against somebody and bet on it. Does the fact that I choose to bet against someone else playing pool turn the pool table into a gambling device? No.
It's just off point. I mean, we're
don't think
talking
that
about a very simple device. We're talking about a very simple industry. There are machines in buildings. People can walk in, they can put in whatever the consideration is, and they lose. Okay? They put in another coin, they lose again. They have the opportunity to do this. They have the opportunity to do what I understand in the classic sense of the word, they have the opportunity to gamble. These devices give people the opportunity to gamble. Is that legal?
These devices are legal, and if they were pure gambling machines, they'd be allowed in casinos, and they're not.
But that's the different answer to not even the question I asked. Is it legal to give people the opportunity to gamble?
I think I've answered several times.
You say yes.
I say yes if your question is, can a device that is not a gambling machine be used by people to gamble? I don't know how you could ever police that. And by the way, there's no evidence that that happens in this record, but I know you're not asking that question.
Yeah, I'm really not. I mean, I understand all of the mechanics of how this works. As Justice Weck said, you know, we have the full record in this case. You can't get to the skill game unless you take a chance.
That's not true. You don't have to take a chance if you use the preview feature. You can choose not to play the game. You can choose not to put any money in the game by using the preview feature first and seeing what's going to happen next. And if for whatever reason you decide, you know what, I don't want to play today and have to play through Follow Me to win, even though I could, I don't feel like doing that right now, you choose not to put the money in and you don't play the game.
Well, that's not playing. You haven't done anything.
You haven't done anything.
Well, you're operating the game. I mean, the game is, we're determining, and the test determines whether the machine itself is a gambling device, not how people are playing it. And that's why it's a good objective.
That's not playing. I mean, the only way that the only reason we're here is that the way there's a profit made is when people place a bet and lose. I mean, I think we could at least agree on that. I mean, otherwise there's no revenue. And how is that not gambling?
Because, as I just said, the test isn't whether people are playing a certain way, it's what the machine does. And the test has plainly been applied to machines just like this over decades, and the legislature's never changed the definition of 5513. Again, go back to the New Ken case, Your Honor. It's a lot like this machine, and that court, it was Superior Court, but then again, it was cited very favorably by this court. You know, that machine was held to be not a gambling device because skill predominated, not because people were playing it one way or the other. You can't fashion a test that in a criminal context allows people to get prosecuted if you have to figure out subjectively what they were doing when they were playing the game. The only way in a criminal context you can make a workable test is by evaluating what the machine does. And that's
Why are you having to do all this subjective imagination when you go in, you put money in, wheels are spinning, and then you see if you won or not? That looks and smells a lot like gambling, doesn't it?
Look, I think, are you asking whether, as you did in Greenwood Gaming recently, whether two different types of machines might look like each other? Sure, I can't deny that. But as you did in Greenwood Gaming against Department of Revenue, it's not just how they look, it's what they do. And actually, critically in that case, you looked at what the Gaming Control Board defined a slot machine to be when you sent it on remand to Commonwealth Court. Not just a simple, hey, look, some factors and features of this game look like that one. You said you got to do what the statute says, and a slot machine under the Gaming Act has to be approved by the board. So Commonwealth Court, when you look at the record again, evaluate what the board thinks a slot machine is. That's exactly what I'm doing here, and the evaluation is, it is not a slot machine under Title IV. It cannot mathematically be a slot
Well, I
machine.
don't think we're talking about that any longer. I think we're talking about a more basic understanding under the Crimes Code of what gambling is. At least I am, okay? I appreciate all of the discussion about incorporating the definition and things of that nature, but I'm at a much more basic level. When we look at these devices, and we take into consideration whether it's gambling, do we look at the potential for reward, the difference in the reward of playing the skill game versus taking your chance and repeatedly gambling your money to hit big? I mean, do people play to win 40 cents after going through 7 rounds with intermissions in order to go through the skill game?
20 rounds.
20 rounds. Or are they playing to hit big, to gamble that they will hit big?
Well, first of all, we'll never know, Your Honor, because the Commonwealth didn't adduce that evidence at a hearing, and it didn't adduce that evidence at a hearing because it's not relevant.
What evidence would that take? We have in the record what the return is on the skill versus chance side.
You do?
I mean, what else?
No,
what
I
else
mean,
do we need?
the rate to, no, the return to player percentage is, according to our expert, unchallenged, is in the 170% range.
That's,
So that's not, I mean, that's,
okay, so what does that mean? Translate that into dollars for me. Let's say I play $1.
it means if you play with optimum skill,
Not optimum skill. Let's say I play $1. What's the maximum amount I could win on the chance aspect of the game?
it's more than 105%. It's going to depend on the game.
But how much more? It's a lot more, correct?
It can be. Sure, it can be.
What's the maximum? It's more than 100.
It depends on the game, and it depends on what you get a bonus round. But it's more than 105%. Absolutely. You're right.
Okay, and the most you could win if you play the skill game after various intermissions, taking notes, et cetera, is how much?
105%.
Okay, that's 5% more than what you put in.
Yes.
Can we take into account when we're looking at this as to whether or not this is gambling?
Well, I think you should take into account absolutely the fact that you can always win at least 105%. Yes, I think you can. But has the General Assembly, let me back up, Your Honor. I understand that there's some level of discomfort with this. It's novel. I mean, it's not actually, because it's been around.
I don't have any discomfort at all. I mean,
Well,
we have a pure legal question. Is this gambling?
And the answer is no. Now we're talking about policy questions. How much of a win is too little or too much of a win? Do we care whether people are approaching the game in a certain way?
One of the factors that we take into account, the legal test, one of those factors is the reward.
But it's conceded.
That's not a.
Reward and consideration were conceded. They were both stipulated to that the game is a reward game and a consideration game. So this isn't a reward case. It's not a consideration case. It's why the cases, some of the cases cited by the Commonwealth, like the Lund and the Lindy case, are in opposite. They're not about skill. They're about consideration. We stipulated that there's consideration and reward. But Your Honor, if what you're getting at is how much reward should matter, that sounds an awful lot like a policy question that the General Assembly ought to handle.
Okay, let's get back to my other question, because I'm not sure. Maybe you answered it, maybe you didn't. Is it legal in Pennsylvania to give people the opportunity to gamble?
Well, I think I have to say yes, because in my example, the Commonwealth can't stop me and my friend from playing pool and betting on the outcome.
In a slot machine.
Pardon me?
In Pennsylvania, is it legal to allow people to gamble using a slot machine?
Well, no, and fortunately, the Commonwealth and the Commonwealth Court defined slot machine for us with respect to 5513, and they did, as this court always does in statutory construction cases, looked at the dictionary definition of slot machine, and the slot machine definition in dictionaries that is applied to 5513 is a gambling device. So really, we keep getting back to the core issue here is how do you define gambling in terms of a device?
I ask you then, so it's not gambling, it's not a slot machine, it's not a hybrid slot machine, it's not a skill slot machine, it's this other thing, it's this game of skill. And wouldn't we expect then that there'd be this whole world out there of people with bragging rights? There'd be Facebook groups, I guess, and there'd be, certainly we'd expect to see on your games, like what we see on a pinball machine is like, you know, initials JMH have the record, and this one's in second place. But there's nothing like that on your machines. There's nobody vying to be crowned the king or queen of the greatest skills at your skill game, is it?
Well, Your Honor, that's the problem with going outside of the record, because you have to take my word for it when people actually do put up on YouTube how to win all the time. They call themselves dotters. They're people who play the game and make what our expert testified is the $20 an hour thereabouts by playing the game skillfully.
By winning the Simon Says all 20 rounds?
Yeah. I mean, that's not in the record, but I'm as an officer of court, you're asking the question, and I'm giving you the answer. They actually do things like that. And not surprisingly, there are probably videos of people playing the game in the way that doesn't use Follow Me, because the game's built to be played in a lot of different modes. But
can you allow them to play it in that mode where it is pure gambling? I mean, that's the question I keep getting back to. Is that legal?
Well, I think I've answered it. I've tried to answer it, Your Honor, in my sort of slippery way. The answer is
you said it, not me.
The answer is unquestionably yes, because there's no manageable criminal law standard that otherwise we can apply to devices. Like my pool table. I mean, there is no way to fairly and even-handedly implement a crimes code provision that is dependent on what's going on up here when I sit down and play pool with my friend.
Well, but the reason why your pool table thing doesn't work is pool is a game of skill.
Yes.
It's not a game of chance.
Right.
You have to concede, and you have. I think there's been a lot of concession on this point. Part of this game involves a game of chance. Even though they know the next roll may be bad, they keep playing because they're hoping the next one will be good. And that's pure chance, unlike pool.
No, look, I'm not denying that there is chance in this game. I couldn't, because the record in the trial court held that there was chance in the case. But certainly that judge evaluating the game, watching it being played, understanding what was going on, hearing from the Commonwealth's own witnesses about the fact that you can win it every time, and 3 of them did. 3 of the 4 witnesses testified, hey, I won this game every time.
Well, there's somebody who went out to Vegas and amazingly won every time. Somebody out there. I mean, can you say that I mean, is it even possible to say that, or let me ask you this, would you deny that when somebody plays your game, they're by definition, they're risking their money in the hope of gaining more money than they wagered? I mean, that's the essence of what they're doing, right?
Yes, I deny it, Your Honor, because the game is built to be played in multiple different modes and ways. There may be people who play like that, and there may be people who look at the game, put their money in, see what the next screen says is going to happen, and decide to take their money back out.
So it's not gambling. It's like a sport. It's like you want to tell us this is like, maybe this will become an Olympic sport because there's so much skill out there. There should be leagues, and and the media should be covering like the best athletes at these skill games.
Well, in some respects, that already happens, Your Honor, with esports. I mean, this is not a new phenomenon. I mean, it's new for this court.
Is
but
this covered on esports?
No, but
I must have missed this
No,
on
no, no.
ESPN 24 or something.
no, but there are sports out there or games out there, online gaming, that involves skill contests that people wager on in casinos. I mean, it's the idea that, I mean, this is really back to my point earlier in your question about what a skill slot machine is and why the industry developed. The idea was to make a game that had more interactivity but was still in casinos, one that always was going to let the house.
Well, the idea was to make money.
Yeah,
and
right.
There's nothing criminal about that except when it violates the crimes code.
Absolutely right. And I continue to contend this one doesn't, because it's been built to satisfy the extant predominant factor test.
Mr. Haverster, just one, I'm sorry, Chuck.
Go ahead, go ahead.
You said there are multiple ways someone could play the game, right?
Yeah.
So one way is, well, I guess they're not playing, but let's say they are playing and they press the preview function in the middle and they just say, I'm walking away, I'm done.
Right.
They make the choice to go away. That's one person,
That's one
right?
way.
Another person might be, I really don't care what the chance result is, I'm trying to get to Simon Says, and I'm going to use my skill.
Yes.
There's a third person that does the idea of, I don't care what the next screen is, I'm going to keep pressing until I get the jackpot. And I'm going to be here and I'm going to put the money in and I'm going to keep going, right? That's the third person.
That is a third person.
Of those three, which one generates the money?
Well, there's
For your
actually,
client.
There's actually a fourth one, but
Of those four,
Okay.
which one generates the money for your client?
in the
Which
short,
one makes the model economically feasible?
in the short term, it's naturally the people who are choosing to play what the Commonwealth characterizes as the fun way, the one where you're just like at a bar, you're just seeing what happens with the game. That's where I assume the game makes its most money. I don't have it economically modeled out. But that's not the sine qua non of what satisfies the predominant factor test. It's not whether it's somewhat profitable, a lot profitable, a little profitable. Again, Your Honor, with respect, that's a General Assembly question. I mean, if the General Assembly wants to say, we're going to treat these games as allowable to be in VFWs and fraternals and bars, but only if the profitability is X. Well, it can do that. I mean, it did that with the Gaming Act. It said in casinos always have to make money. They always have to make money. That's what the 85 to under, the 100 is about. General Assembly can do that. And look, it's trying to. I mean, we know we're not blind to what happens across the hall. We all know there have been multiple efforts in the past year, including really recently, to regulate these games differently than they're regulated now by the Crimes Code. But we're talking about policy issues. And Your Honor, respectfully, I think you and I are talking about policy issues, as in, when is a game too much like gambling that even though you can win it every time, we still want to regulate it more like gambling than like an arcade game?
I'm not arguing that at all.
Oh, I like that argument.
Trying to apply I'm asking I think the question that's before us is what happens with your client's machines gambling. And my question is basic. I mean, whether or not there's a skill component or not, anybody who walks into an establishment where these machines are present have the opportunity to gamble. And you're telling me that's okay.
Well, I'm telling you the answer is no, based on decades and decades of this court's interpretation of 5513, which of course is organically part of the statute now, because since 1983, this court has held you determine whether a machine is gambling for purposes of 5513 by the predominant factor test. And I think, and we argued, I believe persuasively to the courts below, that we are in fact a predominant skill game, and that's why we're legal under 5513. If the General Assembly wants to change that test, it should. As I said earlier, it's tried 8 times in the past 5 years, I think.
We can't concern, there, as you know as well as we do, every single day in this building, some legislators proposing something, and for whatever reason, it goes away, it doesn't get passed. That's the nature of the beast, right? We have to deal with the statutes that they actually have passed and the governor actually signed, which is why I began by asking you about the Crimes Code and the Gaming Act, and which is why I take it you have to keep insisting, and I understand it's your position, that when you go around Pennsylvania and you see these things, that what people are doing at these things, at these terminals, is somehow some sort of skill rather than gambling. That's the bottom line of your position, right? That has to be, right?
Well, I'm saying that the game can be won every time on skill because the test is about the game. It's not about the people.
Then it's not gambling.
Then it's not gambling, right? Because the test for gambling under 5513 for machines, not people, for machines, because it's the only objective way we can determine whether a crime's been committed, is the predominant factor test. And I think my articulation of that test, which is shared by courts around the country, I think this court, is a very good, fair, and common sense one. If skill can beat chance through the whole game cycle, and I can always apply skill no matter what chance does to me, and I can win every time, then it's a skill game. I think that is a correct articulation in the real world of what that test looks like.
All right, Mr. Haverstick, sadly, I'm going to have to bring this argument to a close.
Oh, Skill-O-Rama's still got another one to go, so.
I know you have more to say, but I think we've heard enough. Thank you both.
Thank you, Your Honor.
Mr. Minner, we're going to take a 10-minute break. Chairman, or would you call the next case?
Pennsylvania LLC versus Commonwealth Pennsylvania Department of Revenue, representing the Commonwealth, Mr. Michael Sprinzy, representing Comm, Mr. Matthew Hack.
This case concerns the same skill games that were the subject of our last argument. Here in this appeal, the Commonwealth Court concluded that these skill games could not be regulated under the Gaming Act as unlicensed slot machines. We are asked to address the propriety of that ruling. Please proceed.
Thank you, Madam Chief Justice, and may it please the Court. My name is Michael Scarinci. I am a Senior Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing the Department of Revenue, the appellant here. The Commonwealth Court correctly determined that POM's game is a slot machine, but its conclusion that this game is not subject to the Gaming Act was erroneous. That interpretation is contrary to the plain text of the Gaming Act, violates fundamental principles of statutory interpretation, and causes absurd results. The legislature intended to authorize only limited gaming in a controlled environment, but we do not have limited gaming in a controlled environment in this Commonwealth. There are tens of thousands of POM slot machines throughout the Commonwealth, in convenience stores, in bars, in gas stations, in pizza shops, in laundromats. And because of the Commonwealth Court's erroneous interpretation, this game is not subject to the kind of regulation, taxation, and consumer protections that the legislature envisions for slot machines. To vindicate the legislature's intent, this court should conclude that the Gaming Act prohibits POM's slot machine. There are two questions before this court. Is POM's game a slot machine? And if so, whether POM's game is prohibited by the Gaming Act. To play POM's game, a person places a bet for the chance to win more than he's bet, provided spinning reels land along a pay line. That's the prototypical image of a slot machine. POM's only response to that is that a slot machine is not a slot machine unless it's been approved by the board. But what approval by the board does is make a slot machine legal. In other words, Section 1103 defines what is a legal slot machine.
Yeah, but I don't think that's the question. The question is who in the Commonwealth of Pennsylvania regulates illegal slot machines, and why isn't that under the Crimes Code? Why do you get to choose what slot machines are legal and go after the people that are operating illegal ones?
So, if we turn to Section 1317.1E and 1518A4, those two provisions prohibit and then criminalize the lack of board approval. So a person who manufactures, let me just turn to the section itself. No person shall manufacture a slot machine for use within this Commonwealth unless the person has received a manufacturer's license.
Yeah, but that doesn't say you can then go after, that's proving my point, is that you provide the license that gives the imprimatur for them to operate legally. If they are not operating legally, then it's a Crimes Code issue.
It would be a Crimes Code issue, and it is also a Gaming Act issue because...
Where in the Gaming Act does it say, in clear and unmistakable language or by necessary implication, that the Gaming Control Board has the authority...
Okay, yeah, I understand your question now, Justice Brobson.
Sorry, what?
I understand your question now. I think this is where the Commonwealth Court went wrong. It focused more on who regulates slot machines as opposed to whether it's subject to regulation by the Gaming Act. The Gaming Control Board does have a role to play in the regulation of illegal slot machines. I discussed this in my brief. The board's Bureau of Investigations and Enforcement, they have the authority to cooperate, to refer criminal violations such as 1518A4 to the Pennsylvania State Police. They also have the authority to cooperate with the state police, the local district attorneys, and the Attorney General. That's found in Section 1517. So I think that's where the Commonwealth Court went wrong. My point is that POM's game is subject to regulation under 1317.1. I mean, by regulation, let me just clarify, I mean, it's prohibited.
Well, sure. I don't think they're disputing that. I mean, they're disputing whether it's a subject of regulation, but let's assume you're correct and it's prohibited. That means it's an illegal gaming device. Correct. That is subject to prosecution under the criminal code. Yeah. You haven't answered my question. Where in the Act does it say the Gaming Control Board has the authority to bring enforcement actions against illegal gaming devices?
I thought I did, and I apologize if I didn't. I said that with the Bureau of Investigations and Enforcement is part of the Gaming Control Board. They would refer a criminal violation to the state police, and then they would prosecute. They can also cooperate in a...
But they wouldn't prosecute him for violating the Gaming Act. They would prosecute him for committing a crime.
Well, 1518A4 is a crime. It subjects a person to first offense as a first degree misdemeanor.
In Justice Brobson's scenario, that the they is PSP and OAG.
Correct, or local district attorneys, and they would be prosecuted both under 5513 and under 1518A4, which prohibits the manufacturing, supplying, or placing into play any slot machine without the approval of the board. A second offense would be a felony. So in any criminal indictment, there would be more than one charge under the Crimes Code and under the Gaming Act.
So that just for clarify, so in this context, just to further spin out Justice Brobson's scenario, what's being done by the gaming board in such a scenario is simply identifying that this is that, and therefore we're going to tell the authorities about that.
Exactly.
And then they'll handle it under the Crimes Code.
Exactly. It's undisputed here that POMS has no license to operate their machines. So it's operating in violation of both the Crimes Code and the Gaming Act. And we've pointed, I said, as to 1317.1E, 1 and 2, and 1518A4. Now, just to come back to 1317.1E1, I want to make clear that the Commonwealth Court did not even consider that provision. We mentioned it 4 times in our brief. They did not even consider it. Justice Wecht, as you pointed out in the first case, that's clear error when a court does not consider an argument that we made. And that section, just to highlight the language, is not concerned just with licensed slot machines in licensed facilities. It uses the term for use within this Commonwealth. There's no geographical limitation. And if that language wasn't clear enough, that language was changed in 2017 because it used to say, no person may manufacture slot machines for use within this Commonwealth by a slot machine licensee. That language, by a slot machine licensee, was struck out. Again, making very clear about the legislature's intent here is that not just licensed slot machines and licensed facilities, but anywhere where there's illegal gaming. And as far as 1518A4, as I mentioned before, that applies to placing into play, manufacturing, supplying, and placing into play. And where the Commonwealth Court went wrong here is it offered an unreasonable interpretation. It took the phrase on the floor of a licensed facility and applied it to the entirety of that section. On the floor of a licensed facility is meant to modify only display, not the verbs that precede it, such as manufacture, supply, or place into play.
Counsel, can we just go back to because I didn't think this case originated from criminal referral. Doesn't this case originate because the city of Philadelphia and not the attorney general, not a district attorney, not somebody else, but a state agency or a city agency confiscated machines?
That's correct. What happened was...
so where under the Gaming Act is there authority to confiscate those machines?
That was... the city of Philadelphia did seize those machines. I'm not sure if that was under the Crimes Code or under the Gaming Act. What then happened as a result, and this goes back to 2018, then POM commenced this action against the Department of Revenue and said the seizures are illegal, and joined the Department of Revenue saying the Department of Revenue is being deprived of the sales tax that it would get from these machines.
Right, that's what I'm trying to draw the connection between, because I think the only thing in front of us is whether these machines are regulated, whether the Gaming Act regulates unlicensed machines and allows the agency to go after and seize unlicensed machines, or does that have to be done in a criminal side? You understand what I'm saying? There's an administrative side, administrative agency's authority, and then there's prosecutorial authority from a criminal side.
Of course. Yeah, I think the seizure would have to happen under the criminal side, under the Fourth Amendment. But as I said, I think POM can be charged under both the Crimes Code and the Gaming Act.
But not by the Gaming Board, and not by the
Right. Yes, the district attorney or the attorney general would file a criminal action.
I mean, I obviously have a little bit of confusion about what the nature of the issue is here. Maybe I'll just sit back and listen, and maybe I'll get elucidated.
Okay, Your Honor, I'm sorry if I haven't answered your question. As I said, it was brought by it was brought by POM against the Department of Revenue, claiming that, I think I can clarify for you now. The action that POM brought was saying that, they brought a claim saying, this is legal under the Crimes Code. And then they sued the Department of Revenue as part of that, and the Department of Revenue counterclaimed and said your game is not only illegal under the Crimes Code, it's also illegal under the Gaming Act. Maybe that clarifies for you the procedural posture of how this case came about.
So it started as a criminal matter.
No, it started, POM commenced this action as essentially a declaratory judgment, I believe.
I get that, but somewhere before that, these machines were confiscated, correct? And that
by
was
the
done
city of
under the
Philadelphia.
Crimes Code.
I'm sorry.
And that was done under the Crimes Code.
I'm not sure under what provision the city of Philadelphia seized them. I assume it was, I don't know. I can't answer. I can certainly provide that to you at a later time, Your Honor. And just to turn to for a second, I just wanted to mention two things. One is that as a result of the Commonwealth Court's interpretation, we're seeing sort of the absurd results that have followed here, where you have POM is not subject to the kind of regulation, taxation, or consumer protections that are present in casinos. Just to give you a couple examples here, for casinos, their games are hooked up to a central computer that's regulated by the Gaming Control Board that's able to detect fraud in their games. They have mandated payout percentages under the statute. There are self-exclusions and a 1-800 number for people. The taxation, the 50% taxation that comes from casinos, those are used for treatment for compulsive gamblers. None of that is present here. And I just, the one last thing I want to say, because I think Your Honors understand my argument here, is I just want to respond to something that Mr. Haverstick said here about return to payout, return to player payouts, and theoretical payout percentage. Theoretical payout percentage is what a machine pays out over the lifetime of its life. What it pays out over its lifetime. Under the regulations by the board, it has to be 85%, which is why the house always wins, because the house gets 15% back. For POM is talking about what its game can pay out in theory. If you're a Harvard astrophysicist taking copious notes and you want to play a 12-minute game to get $1 back, your bet back, $1 and another 5 cents. Those are two different things. So unless Your Honors have any other questions, I'll rest on my briefs.
Are there any other questions? All right, let's hear again from Mr. Haverstick. Do you have a chance to get your breath?
And a sip of water. May it please the court, Madam Chief Justice, Your Honors, my name is Matt Haverstick, and I represent POM of Pennsylvania. You know, I thought this was going to be the harder argument of the two today, but I suspect it might go a little quicker. Look, unlike the first case where we were talking about a per se gambling device, that is one that is illegal only if it can be used for nothing else other than gambling. So if it has some other use other than gambling, it's legal under a per se analysis. We're now in the realm, according to the Commonwealth, of the Gaming Act, which is significantly broader, at least in the language as they read it, which reads out, as we discussed in the first argument, reads out kind of key sections. But the coverage of games in Section 1103 for slot machine is significantly broader than what you would look at in a per se analysis that we did in the first case. For instance, the coverage of the games that counsel suggests are controlled by the Gaming Act are arcade games, are skee-ball, are the basketball net thing that you can do at Dave & Buster's. They are electronic pool tabs, and as I discussed in the first argument, That's a device that is strictly speaking and strictly regulated by both Department of Revenue and the Pennsylvania State Police and Liquor Control Board. So what the Commonwealth argues now is that sub silentio in Title IV, with the definition of slot machine being as broad as it is, it's supposed to all of a sudden cover categories of devices that may or may not be gambling, certainly are well outside the control of a casino, and are devices that even the Department of Revenue treats as their devices, that is, not regulated by the Gaming Control Board. The evidence of that is, as I said, yesterday's attempt by the Senate to run legislation that would change the regulation on electronic pool tabs. According to the argument we just heard, that shouldn't be a concern of the Department of Revenue anymore. But nothing in the language that says that.
I'm sorry, Mr. Haverstick, pardon me, but you're talking about skee ball and that basketball thing and the Chuck E. Cheese things we took our kids to when they were younger and all those things. Any of those involve wagers where you get money back?
But that's not what if you ignore the sections of the statute that the Commonwealth requires you to ignore to make this argument work, it does capture that. You put money in by reason of chance or skill or both, you play the game, and then you get something out. The something doesn't have to be more than what you put in or less than what you put in.
It has to be of value.
Sure.
And of value implies that you're getting back as much as you put in.
But, Your Honor, no, that's not what of value means. And there are cases that have held, at least in the gambling context, that of value may be relevant for determining whether a device is gambling, but it has nothing to do with whether there's a reward. And the statute doesn't say, again, maybe the General Assembly should rewrite it and make it say it, but the statute doesn't say, under their definition in 1103, what you get back has to be more than what you put in. It just says you get something of value back.
And it's a question of what of value means.
Yes, and I think under its plain terms, that's certainly nobody suggested a value is ambiguous, certainly not the Commonwealth, and I don't think you have to, because a value means just that, something that has value, whether it's a peppercorn, a penny, a stuffed animal, or tickets that you
Well, the
can
Crimes Code talks about gambling. I mean, 1103, it's all about gambling. I started to ask you last time, I didn't get a chance to. What is gambling?
Gambling is wagering money with the possibility outside of your control of winning a lot more. Outside of your control is really the critical element, though, Your Honor. And that's why the analysis that this court, imperfect as you may find it today, the predominant factor analysis for how you evaluate a game like the Pace-O-Matic game is so critical.
Do poker and 21, they have any elements that you control at all?
They do, and that's been addressed by courts in the Commonwealth, consistent with the paradigm that I offered up in the first argument. In poker, skill can change how likely it is that you may win or may lose. But at some point, you're at the mercy of the draw of the cards. And poker, like, Texas Hold'em, as we know, has multiple stages of it. I mean, you can analogize it to lots of games, but it's not a flip up the one card and it's done. It goes in stages just like, the skill game does in this case, where you make strategy determinations as you go along. And the courts have held, no matter the fact that skill can improve your chances, you can't ever beat the chance of a bad draw. And that's the difference between poker, and blackjack for that matter, and this game. You can always beat chance by playing the game the whole way through and being good at it.
Are you telling us that you think your follow me feature is involving strategy?
Sure.
Isn't it just it's memorization of those circles?
Well, Your Honor, there was testimony about this at the hearing in the first case. One of the strategies employed by, and I forget who it was, the fellow got out a notepad and realized, you know what, I can just kind of record the numbers as they come up and treat it like a phone keypad or something like that, and I can use a pad and a paper to beat it. That's a strategy. And there's nothing in the game, you're allowed to do that. The game doesn't, there's no rule in the game that says you can't use a pen and a paper or some other creative strategy to play a memory game. So yeah, I think it absolutely has strategy. In fact, our expert in his report, unrebutted, told everyone the game is so skill-based that you can employ a strategy where you only play follow me sometimes, and sometimes you play, you know, as you call it, the pure chance part. If you really want to maximize how much you make and make more than the $19 an hour my calculations show you made just by playing follow me every time, there's a really smart way you can do it, and you can actually make more than $19 an hour, and it's a combination of strategies for gameplay. So, look, the fact that not everybody does it is a separate question from whether that game is a per se gambling device.
Well, it's a bit of an understatement when you say not everybody does it, right?
Well, we don't know.
What's the record say about how many people have ever won? Won all 20 rounds.
Well, of the 4 people who were in the courtroom, 3 of the 4 beat it on 20 rounds. So 75% is what the record says.
Mr. Haverstedt, can I go to the statute? Can you
Yes.
tell me how a company runs afoul of the prohibition of section 1317.1E?
In the licensed facility context, because I think that statute, as we have to acknowledge, is a licensing statute talking about the definition of conduct of gaming in the definition section is the licensed, you know, gambling or gaming licensed under this part. It would be, Your Honor, if a licensed facility bought a slot machine or, you don't even call it a slot machine, some other apparatus to be used in a casino.
Well, clearly a casino putting in an unapproved slot machine would be it.
Yes, that's how you...
But the prohibition, and I'll get to the consequence of the prohibition in a second, but the prohibition seems to be broader. It deals with, and there's a lot of licensing in this statute. You license facilities, you license the drywall person, you license, you know, there's a lot of licenses that this act, they got their money every chance they could get it, right?
Except here.
Well, right, I guess that's the question. But they're saying that your machines violate this prohibition.
They're not licensed.
Tell me why they don't.
Because...
Before we get to the consequence if they do.
Well, first of all, and I think at a most basic level, we don't believe we're a slot machine.
Understand.
But that's important, right? Because the licensing provisions apply to a slot machine as defined under Title IV. And if we don't meet the Title IV definition of a slot machine, that is one that is approved by the board, then...
See, but the problem is that's circular.
I know.
Because the way it works, and you probably have done, I don't know if you've done licensing or not, but the way it works is you represent a client who has a machine that they want to sell to a casino in Pennsylvania. They go to the board and they say, here's our machine, approve it. They don't, it's not like this abstract, we generally approve all tic-tac-toe machines. It's the slot machine approval is specific to each manufacturer, each licensed facility.
Yes, but that answers my question, and I hope answers your question. Based on the regs, and I discussed that in the first argument, we cannot be approved by the board. We are outside of the coverage of what the board says.
No, but you're going to this case. I'm trying to ask you generally about how the statute works. And if, as the statute works, the slot machine definition is referring to approved slot machines, and slot machines are approved by company, not generically, your argument is circular. It would have to be someone trying to put a slot machine in a facility that is not licensed to do it, but they would never, that would never meet the definition of a slot machine.
Well, but now we're talking about two different things. If we're talking about the licensing provisions purely and how one can run afoul of them.
No, I'm talking about the prohibition that says no person may manufacture slot machines, table game devices or associated equipment, or interactive gaming devices or associated equipment, I guess that means my cell phone, for use within this Commonwealth unless the person has been issued the appropriate manufacturer license under this section. Now, your answer to that would be, Slot machine is specifically defined to include only board-approved machines, but machines are approved during the manufacturing licensing process, so it's circular.
Well, here's a better way. There's a better
Am
way
I
for me to
wrong?
answer
Am I
this.
wrong in that interpretation?
Well, I think what we're missing in the analysis is what we believe is it's the fact as far as this record is concerned. And I got to say again, I'd love to be able to come to this court and argue outside of the record and talk about facts that aren't in the record. I mean, remember the procedural posture of this particular case. They filed a summary relief app, so they were stuck with the averments we made in our petition for review, and our petition for review averred we can win 105% of it.
Mr. Haversteck,
I know.
this to me is a statutory construction case. The record may be okay for you, but I'm trying to understand the statute. And I'm not trying to understand, how can we ascribe to E1 the strict statutory definition of slot machine, which refers to only approved devices by the board, if the only way you get a device approved is through the licensing process to be a licensed manufacturer?
Because it's a gambling statute, Your Honor. Because if the device we're talking about is not a gambling device, it's like saying, it's like making that argument for
Let me just say,
a car.
A slot machine would never ever violate E1 if you applied the statutory definition of slot machine.
No, I think the statutory definition of slot machine in Title IV is one that must be a gambling device. It can be nothing other than a gambling device. And
So you're okay with, for E1 purposes, ignoring the part of approved by the board in the definition of slot machine?
Because the only thing that's required to be approved by the board is a slot machine, and for this purpose, that means a gambling device. And we know that because of...
So I just want to make sure, so for 1317.1E1, when it says slot machine, that means anything in the slot machine definition absent the provision that says board approved. If you're a slot machine, even though you're not, if we disagree with you,
Yeah.
and we say this is a slot machine, but for the fact that it isn't approved, it violates the prohibition.
I don't think it does because, well, I mean, look, depending on how you define it.
You have to concede that at least. You have to concede that, don't you?
No, I don't think that I do, because fundamental to the premise of the question is that we are a gambling device. And I think the statute regulates only gambling devices.
Well, it doesn't say gambling device, it says slot machine.
But slot machine is defined in the statute and in the regs, and both in the express language in the definition section 1103 and in the context of the statute, which is a gambling statute, that it's a gambling device.
I know you keep wanting to go that, okay, but give me, just follow me for a second. Follow me.
20 rounds.
I really didn't intend to say that. I didn't. The definition of slot machine, and I know I focused on this in your last argument, I'm focusing on this one. The part that I find problematic with the other case is that the definition of slot machine in the Gaming Act is specifically referring to board-approved things,
Yes.
right?
Yes.
Specifically. In the prohibition provision, it uses the word slot machine. It makes no sense if you apply strictly the statutory definition of slot machine in that section, because you would never have a board-approved slot machine violate that section, because board-approved slot machines are approved in the process of the licensing of the manufacturer. So now, are you following me on that?
I think so. Well,
I'm not asking you if your machine's a slot machine. I'm saying
No, I think so, yeah.
there's a statutory ambiguity, I think. I mean, I know you don't want to say that either, but but I don't know how you can apply the strict definition of board approval. I don't know how a board-approved slot machine would ever violate this prohibition.
Well, look, that sounds like if there's a drafting error, it has something to do with regulating gambling machines that have been approved by the board for use inside of casinos. But we're not that. I mean, our argument is central to our argument is there's a universe of things that is regulated by Title IV, and those are things that are unquestionably gambling devices. They can't not be gambling devices one, you wouldn't need a whole new statutory regime to regulate things that aren't gambling. I mean, you know, we had that before. So the only reason Title IV exists is to create my little bottle universe of areas where gambling and gambling machines are legal and permissible. So if you don't look at all of the provisions in that context, I think you can run yourself ragged thinking about comparing things that are outside the coverage and scope of the statute.
Can I pursue that outside the scope thing? So we know from the Crimes Code that slot machine or any device to be used for gambling purpose is a crime. And there's a carve-out for the Gaming Act, which allows certain things and it sets up a regulatory regime. Now there's 3 categories here: slot machine, hybrid slot machine, and skill slot machine. So let's say you're not, let's for the sake of argument say you're not a slot machine, and let's even say for the sake of argument you're not a hybrid slot machine. Let's say you're a skill slot machine, which is defined as follows, quote, a slot machine in which the skill of the player, rather than the element of chance, is the predominant factor in affecting the outcome of the game. It seems to me you're telling us you're all those things except instead of the word slot machine, let's call it a widget, or let's call it something else. Let's call it a game of skill. But then if that's the case, then what could possibly be included in this category of skill slot machines that would not be what you have?
Aha. This is what we were talking about before, Your Honor, when I was telling you about the Space Invaders game that became, and that's one example of it, that became popular in the mid part of the last, and I'm going to yell at myself for going out the record, but that's the only way I can answer your question. That the skill slot machine that's being referenced there is a type of slot machine that still requires the house to make money from a return to player standpoint. That means the game, even though it has skill elements, and even though you can affect the amount you win with skill, you still cannot have a return to player equal to or 100%. That's in the regs. That's the difference between a skill slot machine in the gambling casino context and a skill game in the non-gambling context.
But you're incorporating the regulation into a definition, and that's not how statutory construction works.
Well, but
You're saying the definition of slot machine is broader than the definition.
No.
It includes slot machines in the definition that comply with the regulations.
Actually, Your Honor, I'm not.
What about slot machines that meet the definition that don't comply with the regulations?
Wait, well, let me answer. May I back up, because I want to respectfully correct you on the statutory piece. It's not just in the regs that this is spelled out. It's in the statute itself.
That's fine, but I'm just asking you, what happens about slot machines that meet the statutory definition of slot machine in the Act, but that fail to comply with the regulations? They're no longer a slot machine?
They're not a slot machine that's approved by the board and cannot be in a casino floor. So therefore, they are outside the coverage of the Gaming Act. They cannot be on a casino floor because they will not be approved by the board. Why will they not be approved by the board? Because they're not gambling machines. The board only approves gambling machines.
So it's okay for us to have a slot machine that meets all the definitions of this definition of a slot machine, a skill. I think Justice Weck's saying, what is it called? A skill? What's the third category?
The skill slot machine.
Skill slot machine. It's okay. It's not right. It doesn't come within the board's purview. If you meet the definition of a skill slot machine, but you say, we can't have those payouts, because if we have those payouts, then we have to be licensed. So we're going to have worse payouts, and now we're unregulated.
No, you're regulated by the Crimes Code. If you're a gambling machine existing outside the bottle universe of casinos and Title IV, you're what you always were. You were illegal under the Crimes Code.
But the statute has a prohibition of slot machines that aren't approved by the board. 1317.1E1.
Inside the casino context, not in the world at large. There's nothing in the statute that indicates the coverage of Title IV is all of the Commonwealth. To the contrary, there's a lot in the statute including the 2017 amendment that added in skill slot machine that indicates that Title IV is only focused on a really tight geographic area, specifically categories 1, 2, 3, and then in 2017, category 4 casinos, which strictly limit where you can put slot machines that are allowable under the board. And the max, actually, at a Cat 4 is 300 games. The places where skill games are in Pennsylvania are places like fraternal organizations, taverns, bars, VFWs, where there's maybe 1, 2, 3, 4 games. There is nothing in the statute that indicates the gaming board, or the Gaming Control Board, has regulatory authority all over the Commonwealth, all 67 counties. And it belies common sense. I mean, we heard about the Bureau of Enforcement. They're not Act 120. They're not certified law enforcement officers. They're not law enforcement regulators. They don't have a legal right as they do in casinos.
How does that bear on the question of whether your client is doing something that violates the crimes code?
Well, we're not here, I thought, on the Crimes Code case anymore. Now we're on the Title IV case.
Fair enough.
Look, I'll go back to it if you want, but I think there's at least implicit in the Commonwealth's argument that if they're not regulated by Title IV, well, they're just going unregulated and it's chaos and it's the Wild West. And that's just simply not true. I mean,
What is true, though, is that your clients aren't paying any licensing fees. That is true, correct? I mean, the genesis of this entire Gaming Act was in large part to generate revenue for the Commonwealth of Pennsylvania that was otherwise going somewhere else. So what you're describing is a system where there's this complicated scheme that controls the industry and controls who pays licensing fees and generates money for the Commonwealth, except your clients, who can operate outside of the licensing scheme. Forget about the criminal aspects of it for a moment. Put it in the context of what the Gaming Act did. And so there's a complicated scheme where everybody pays a lot of money in order to operate within the scheme. And then there's your clients who operate outside of the scheme and don't pay any licensing fees, which sort of explains the requirement that manufacturers of slot machines can't sell them within the Commonwealth unless they're licensed. You're capturing that revenue that is otherwise a significant component of the Gaming Act.
And Your Honor, the General Assembly understood that, and it passed Title IV, and it passed the 2017 amendments regardless. In fact, it expressly talked about not covering skill games like the ones in bars and fraternals when it passed Act 42 in 2017 and said, we're not talking about those things. You raise an excellent point for the General Assembly. I think the company's...
I'm just trying to understand why the Act refers to licensing of manufacturers of slot machines in the Commonwealth of Pennsylvania. I mean, Commonwealth of Pennsylvania is a broad term for use in, for distribution in the Commonwealth of Pennsylvania. To me, that would indicate a broad scope of the application of the licensure requirement.
Except for the more particular geographic limitations of the coverage of the Act, which make it plain there are only a few places in the Commonwealth where these types of games, not just slot machines, but table games and other gambling devices can go. And it's not everywhere in the Commonwealth. The board does not have the authority to conduct unscheduled and warrantless survey sessions everywhere in the Commonwealth.
Unless within the Commonwealth means what it says in that section that says manufactured within, for use in, distributed in the Commonwealth.
But you got to go back to the foundational definition of the conduct of gaming, Your Honor. Remember, this is all about the conduct of gaming as defined by Title IV, and the conduct of gaming under Title IV are these strictly construed little islands of permissible gambling in the Commonwealth. Not everything in the Commonwealth. Remember, this is an exception to the Otherwise, continuing crimes code possibility or likelihood, if you're a gambling machine, you're illegal, a gambling machine. So
But it doesn't say for use as described within this title. It says for use within this Commonwealth. I mean, I understand you're saying Commonwealth doesn't mean Commonwealth. You're saying Commonwealth means Commonwealth as defined narrowly pursuant to other terms of this title, but that's not what it says.
I know, but whenever there's a statutory interpretation, Your Honor, as we know, the specific provisions control the general. And it is expressed in the statute that there are specific geographic areas where the board controls, because those are the specific geographic areas where the board is allowed to permit gambling and regulate gambling. That is not the whole Commonwealth. And look, the proof, frankly, is in the pudding. The board doesn't agree that skill games are regulated by Title IV. The board has, to the contrary, taken the position, you know what, under the strict, not even the strict, under the language of the statute, we don't regulate skill games. We might want to someday, but as of right now, we don't under the language of the statute. They acknowledge what I think everybody in the Commonwealth has to implicitly acknowledge, and that is the Gaming Control Board has a sphere that it controls, and that's not all of Pennsylvania. It's licensed facilities, and that makes sense because Title IV was a licensing scheme. It wasn't a broad-based attempt to regulate gaming across the Commonwealth.
So you brought this action as a deck judgment action, not against the board, right?
No, we didn't.
Why did you bring it against, why did you bring it against the Department of Revenue in the city of Philadelphia as opposed to bringing it against the board?
Well, our belief consistently has been, as the board, I think, agrees, is that the board's not a proper party because we're not controlled by the game.
What were you trying, just explain to me again, I don't understand how the issue that we're arguing translates to the parties, this part of the Commonwealth here.
Here's how it happened. There were two parallel actions that were consolidated in Commonwealth Court, one against PSP, one against the Department of Revenue in the city of Philadelphia, and both of them were deck actions saying, under the crimes code, the pay-somatic game is a legal game of skill, and it's not a per se gambling device, inter alia, because it can be used for purposes other than gambling. At some point in the proceedings, before there was discovery, the Commonwealth filed a summary relief application.
No, but I get that. I understand what you're saying, but what is the nature of the dispute with the Department of Revenue such that you brought the declaratory judgment action against the Department of Revenue?
Why were they an appropriate party? Yeah, because
why'd you sue them?
Because we alleged that the act of seizing these games unlawfully by, for instance, PSP in the city of Philadelphia was depriving the Department of Revenue of tax dollars that these games pay in sales tax. Nobody challenged us on it, so
it just seems like they seem to be. Okay, I'll figure it out. But it just seems like an odd. If your argument is that your games are not regulated by the Gaming Act, which I thought was what this case was about.
Yes.
It would seem that you would sue the Gaming Control Board, not the Department of Revenue.
But it wasn't, though. I beg your pardon, Your Honor. It wasn't. That wasn't our argument. That was in the summary relief application. We never said a word about the Gaming Act because we didn't think it applies, and we don't think it applies. The Commonwealth at some point said, no, the Gaming Act applies too.
What standing does the Department of Revenue have to argue the Gaming Control Board's authority?
Well, it's especially when the Gaming Control Board didn't want to get in the case. I mean, and was. So
I'll figure it out.
Yeah, but it's a good point. If they are right, and the Gaming Control Board is an indispensable party because the Gaming Act actually is at issue, then this whole case needs to go back down because then not every party necessary for relief was joined. I mean, this case couldn't have gone forward if the Gaming Control Board wasn't in it, pursuant to their theory.
Mr. Havishik, this came up briefly during the Commonwealth's argument, but by what authority did the city of Philadelphia seize the machines?
Crimes Code.
It was under the Pennsylvania Crimes Code.
Yep, it was their city, it was police, vice department, it was Crimes Code.
Thank you.
To my knowledge, there may have been one attempt by PSP to bring a seizure under Title IV, which it dropped.
Okay.
And look, again, there's what Commonwealth argues and then what it does in the real world. Harkening back to the first case, when we had the Commonwealth's expert on gambling investigations on the stand and under cross-examination, his testimony about what the applicable standard was to determine whether the Pace-O-Matic game was per se illegal, again, can it be used for only gambling, was, oh no, I use a predominant factor test. He didn't say, I also look to Title IV and the definition of slot machine under Title IV. He didn't mention Title IV at all. So in practical terms, the department and the Commonwealth understand that's not the test that they go to court under.
Okay, any other questions? I hope not.
No.
Thank you.
Thank you, Your
Very
Honors.
much. Thank you both. Mr. Minner, we will take a lunch recess until 1:15. not saying it's your fault, but we have cleared the courtroom. The crowds have dissipated. Would you call the next case, Mr. Minner?
Erie Insurance Property and Casualty Company versus David Peter, representing Mr. Peter, Mr. David Siegel, representing Erie, Ms. Audrey.
In this case, while working as a subcontractor on a work site in 2015, Appellant fell and fractured his neck. At that time, Appellant was the owner and sole proprietor of his business and its sole employee. Appellant's workers' compensation insurer was not notified of his injury until 2017. Under Section 311 of the Workers' Compensation Act, notice must be given to the employer within 120 days of the injury, or else the claim is forfeited. We granted allowance of appeal to determine whether, in circumstances where the injured claimant is also a sole proprietor, the employer, who must be notified pursuant to Section 311, is the insurer who bears the ultimate liability for the claim. Please proceed.
Good afternoon. May it please the court, I'm Daniel Siegel, and my associate is Krista High, co-counsel on this case. This is a matter that concerns, obviously, the interpretation of Section 311, and as a practical matter, it also concerns reading a few sections of the Workers' Compensation Act together to determine what they mean. And when you read them in that way, they really do make it clear what was meant. And there's no need, as a practical matter, for this court to write in an exception to the law. It's a narrow issue. It comes up rarely. This man had very severe injuries, etc. But it comes down to Section 311 requires notice to the employer, and that's the word that is used in Section 311.
How do you describe the operation of giving notice when the employer and the injured employer are one and the same? Should we understand notice to be sort of instantaneous, or?
That's what it is. It's a fairly unique situation. It does happen, but the employer in that situation is the employee, and this is one of those cases.
Does there have to be a formal ceremonial self? I'm giving you notice. Thank you, self. I'm joking,
No.
but I mean, what?
No, but-
like, is it a derogation of the statute in some way, or to have a fictional notice giving?
Well, it's essentially rendered unnecessary because he knows. And as a practical matter, and this is unusual circumstances where he had a catastrophic injury, was not something like that. But in most cases, contrary to what the Aplt wants you to believe, most cases you're not going to have this circumstance. Because if you don't give notice to the insurance company, which is done under Section 438 of the Act, and that is the onus of the employer has to report all injuries. So it changes from what the employee has to give to then the employer's obligation. In that case, you would have to do it because, as a practical matter, you wouldn't have your medical bills paid, you wouldn't get your wages paid, and as a sole proprietor, you normally need those because you need sustenance to do that. So using it and saying, oh, you could wait a long time, that's unlikely to happen. And as a practical matter, it can be an insurance policy decision to put the language in. I actually looked at my policy before I came here, and it said your duty is to report all injuries promptly, so that it tells the...
What's the consequence if you don't?
If you don't...
Under the Act versus your insurance policy.
Yeah.
What if the employer, under the Act, does not report the employee's injury to the insurance carrier?
In a normal situation or in this situation?
Any situation.
Okay.
If employer means employer, it means employer in any situation.
Yeah. If the employer doesn't do it, then it's really a contractual matter because the employee's obligation is pure and simple to report the injury.
To the employer.
To the employer. And in most cases, the employee doesn't even know or may not know who the insurer is. And that can change. Even when you have one insurer, they use different names. You don't know.
But what happens if the employer doesn't report to the insurance carrier? There's no forfeiture of benefits.
No, but normally in that situation, the claimant would file a claim petition. And when he files the claim, or she files the claim petition, then the Bureau has records of everyone's insurance. They're public records. You can find them online for any employer in the state, and they would then automatically include the insurer in that notice, in the circulation of the claim petition. And it's interesting.
No, but I don't think
Still not
you're not
answering
answering
the
Justice Donahue's
Still not
question.
answering the question.
Justice Donahue's question is, and she's right, don't talk about ordinary versus disordinary. It's under the Act.
Yes.
Where an employer fails to, now we're not talking about the claim petition, we're talking about the notice of the injury, which is before the claim petition.
Right.
Where the employee, when the employer gets notice, you came to me, you're injured, okay, I got it. But doesn't give notice to the employer within the period prescribed under the statute. They give notice to the insurer within the period prescribed by the statute. Her question is, what's the consequence of that? Because under the Act, it doesn't harm the injured worker.
Right.
Who bears the consequence of failure by the employer under the Act to notify the insurer?
It would, ultimately, it may be the employer, but it shouldn't be the employee because he or she didn't do anything wrong.
I don't disagree with you. I guess what we're asking is, what happens?
Normally in that situation, first of all, under Section 438, unlike the notice requirements, which have time limits, Section 438 doesn't have time limits. You're expected to report
It also doesn't
it.
have a forfeiture provision, does it?
No, it does not. There's no forfeiture provision,
it's
there's
got-
no timely notice. It's just, but the question is, what happens?
What happens?
The remedy's contract-based, right? It would depends on the terms and conditions of the insurance contract.
That would be between the insurer and the employer, because in most cases, if the employer gets notice,
Well, not necessarily. If the workman's compensation insurance contract has a provision that says you have to notify us, otherwise it's a basis for denial, the insurance company could deny it.
right?
No, they can't deny it.
Cannot-
The insurance company cannot deny a notice of claim filed under the Act. The best that they could do is go back to the employer to recover what they have to pay to the worker.
Right. It would be against the employer.
Abrogation?
So thank you for your answer.
Sorry.
That's what I thought.
And, it rarely happens. I can't say that I really ever see that.
I don't know. I've seen cases, Mr. Siegel, and you've seen them too, where an insurer does say that the employer did not give us timely notice of the claim.
Yeah, it does happen. It's not common, but it does happen.
It happened here. The employer here did not give notice to the insurance carrier.
Yes.
So what happened here?
The employer actually, they wound up paying the order to be paid the claim. And it's interesting because in the notice, which was given in approximately early 2017, February 2017, the notice, which is in the record at page 484, the insurer didn't even deny the claim based on the box for checking off the employee didn't give notice. They denied on other grounds, statutory exemptions, sole proprietor, corporate office.
Well, they couldn't have denied on the employee not giving notice. Their point is that the employee didn't give notice or that they didn't get notice of the claim as the insurer.
Yeah.
They're not contesting the employee didn't get notice to the employer.
Yeah, but here it's the same effect because they're trying to deny the claim, and that's why we're here, because they're trying now to deny the claim, even though originally when they first issued a notice in 2017, they didn't even raise the issue then. So arguably it's a waiver issue, and
But I thought we concluded that if the employer
yes,
did not give notice to the insurer,
yeah,
the employee
yeah.
would still get benefits.
He
And the employer and the insurance carrier would have litigation over the consequences of that.
That's possible. It's also possible if they disclaimed that the employee could file a claim against the uninsured employer's guarantee fund, the UEGF, but that didn't happen here. So, yeah, there are lots of scenarios.
Wait. So that's interesting.
Yeah.
So you're saying, going back to Justice McCaffrey's question that I shouldn't have answered, you're saying that an insurer who does not get timely notice from an employer of a work injury could disclaim coverage, in which case the uninsured guaranteed fund would trick in?
That would be possible.
So, so you're saying lack of employer notice to the insurer is a basis to deny coverage?
It could be, depending on the policy. That's a
No,
policy.
I'm talking about under the Act. Can an insurer,
Nothing, yeah.
The Act says nothing about any of that. The Act is mechanical. The Act has Section 311, the employee notice, then Section 438, the employer notice. And it's important also because this court has had other decisions, not on this issue, but interpreting employee and employer and insurer. And the provision in 401 that's been cited in other cases says employer or insurer, not employer and insurer, and that's what what the court has in other cases called one of the procedural sections of the Act, Roman numeral 4.
But that's only when the employer accepts liability,
Yes,
which we don't have here.
don't have it here.
This is the opposite of that.
Yeah, because the procedure is in 438, which says the employer has to give notice to the insurer to make the claim. So it's a very simple process in the Act. What happens after that is it's insurance contract, essentially, between an employer and its insurer, but they don't cover how quickly the notice has to be given. The Act doesn't cover that. It covers none of those types of procedures. It simply says they have to give notice. So if the employer delays, that is a different circumstance. Here, ultimately, it was because they said the employee didn't give timely notice. And it was also interesting because when the workers' comp judge issued his decision, at first he said, well, even it wasn't timely notice because he told the broker, not his insurance company. And that's not anywhere in the Act and opens up another can of worms. But ultimately, you're looking at, a simple mechanism. And as a practical matter, under the Statutory Construction Act, in this case, the language is very clear. 103 says the term employer, is synonymous with a natural person. It does not define or include insurer. Then under 311, it says the employer, once they have notice, they give it. And then 401 is that says either or, and 438 is very clear, the employer gives notice. So all of those provisions are very clear. There's no reason for this court to step in and create an exception for one very narrow situation. And if the legislature wanted to do it, when we've been here before and we've talked about that the legislature could step in and interpret it and change it if it wanted. But under the Statutory Construction Act, we know what an employee is, we know what an employer is, and we know what notice is. And so there's no reason whatsoever to be changing it because of one circumstance. And the legislature uses different terms in different sections, presumably for a reason. So for example, once the employee, if you file a claim petition, then it doesn't, for purposes of a timely answer, doesn't even use either of those terms. It refers to the adverse party in Section 416. So it uses a different term. So you have to presume that the legislature was trying, as it sort of built out the litigation scheme here, to address all of those issues. So that's very clear. And once you have that, there's really no reason for this court to step in to essentially amend the Act for an exception. That's what the Commonwealth Court had done.
You just want us to step in and reverse the Commonwealth Court.
Correct.
Pretty simple issue.
That's what we're asking, and nothing more, nothing less.
Okay. Any questions? Nope. Thank you very much, Mr. Siegel. Let us hear from Attorney Copeland.
Chief Justice, may it please the Court. My name is Audrey Copeland, and I am appearing on behalf of Aplt Insurer, Erie Insurance Property and Casualty Company. Your Honor, I would ask you to affirm the Commonwealth Court. I believe they reached the correct result, that they precluded a claim, but also that they held that where the claimant is both the injured employee and his own employer, sole proprietor. There are all kinds of different ways to say it, I think, but one and the same is probably the best.
What's the textual basis for the Commonwealth Court doing that?
The Commonwealth Court looked to the multiple definitions of insurer in the Act, and that was how they found the ambiguity that then allowed them to apply principles of statutory construction. That also, because section, I believe it's 4 or 5 of the Act, or 3 or 5, I'm sorry, discussed how the employer's immunities and protections and rights also inure to the insurer who is responsible for the claim, who accepts responsibility. In this case, the adjudicated insurer was Erie Insurance Company.
But that doesn't apply unless the insurer has accepted liability. You don't have that in this case. This is the opposite of that. Your client is attempting to escape liability. So the sections of the statute that deal with insurers who accept responsibility have nothing to do with the notice provision that we're dealing with here.
Well, they were the policy, they did write the policy, they sold the coverage. Well, they didn't sell this particular coverage, and that's another issue entirely. And it says, so section 305A says, when an employer purchases workers' compensation coverage, the insurer shall assume the employer's liability hereunder and shall be entitled to all of the employer's immunities, protections hereunder. So that suggests that, you know, once you sell the coverage and it's purchased, that that's an assumption of the liability. And I think that's an important distinction when you look at the various articles of the Act and their chronological order and which ones would apply here to show us which the correct interpretation of insurer is, which we argue as a Commonwealth.
Aren't we looking at the correct interpretation of employer?
I'm sorry.
Aren't we looking at the correct interpretation of the word employer, not insurer?
We're looking at the interpretation, the term employer is at issue in section 311.
What is?
The term employer is at issue.
Correct.
Commonwealth Court found that in applying those principles to the Act, that in section 311, the employer was the insurer, but only where the claimant was a sole proprietor, thus one and the same.
And back to Justice Weck's question, how do you derive that from the language of 311?
I think that the Commonwealth Court did a very good job in examining other decisions of this court, including the Kramer decision and the Brown decision. And in both of those cases, the correct interpretation of employer was at issue. And in both of those cases, it was found to include the insurer, even though that those definitions were in different parts of the Act.
Not yet, what's not in this context, right? The definition.
It's not included in section 311.
Not in this context.
Right. We would say that the same analysis would apply. In other words, in Brown, it was actually the same chapter. It involved section 303, I think common law immunity, some kind of immunities. And you have two choices under the Act. You have the interpretation under section 103, which is simply just the very beginning of the Act, master and servant relationship. Then you have the interpretation at section 401 of the Act, which is which involves the insurer. And that was the section that I read before. Well, similar to the section I read before.
But how would you, counsel, how would you reconcile the existence of the notice scheme that we see in section 438 with your theory that somehow the insurer is also included in the notice provision in 311? Doesn't that seem like a disconnect?
You mean, I'm sorry, I don't understand the question.
Well, 438 438 provides an employer shall report all injuries received by employees in the course of or resulting from their employment immediately to the employer's insurer. So they knew how to say that.
Yes.
So then we look at 311, and they just tell us, shall give notice thereof to the employer. How do you import insurer into 311?
Into 311. Well, in 311, so the claimant must give, 311 is the claimant must give notice to the employer. The other statute is that the employer must give notice to the insurer. However, in this case, I think the Commonwealth Court might have used this reasoning that it's very different from if you have a distinct employer, a distinct claimant. And this, again, they're one and the same. So that's another reason why one of these ambiguity arises.
But
and that's
is it really an ambiguity, or is it just sort of a attempt by the Commonwealth Court to kind of sort of do an equitable rewrite of the statute?
I believe that by this court's precedent in Kramer, it would be an ambiguity, because Kramer said that there was an ambiguity. That case involved a severance offset provision, like whether an insurer was an employer for the possibility of being entitled to that offset to a workers' compensation award. So in that case, even though it was a different section, this court looked to Section 401 definition and defined the employer as including the insurer.
That's the 311 argument in Kramer and Brown. The idea that they're reading the privileges and immunities and protections as going to the insurer. That was sort of the rationale in Kramer and Brown, right?
Right, even though they involve different sections.
Right. So,
And,
but
yes.
here you have two sections of the Act dealing with two different things, each accomplishing notice to two different parties, one to the employer and one to the insurer. If we follow the Kramer paradigm, we collapse those two, when the General Assembly clearly meant them to be separate.
I understand your point, of course, Your Honor, and I respectfully disagree, because I think that the difference is we're talking about an ordinary employer as opposed to, which is somewhat a rare, I suppose it's a rarity maybe in compensation claims.
Yeah, you can't, the problem is you can't let the facts create the ambiguity, right? The question is, can you apply the statute as it is written to a sole proprietorship? And the answer is yes. Right? I mean, if we just apply the statute as written, injured employee has to give notice to the employer. Your sole proprietorship, notice happens there. Then what about 405? Well, then they have to notify the insurer. That's where the breakdown happened here. Right? So you can apply the statute as written to a sole proprietorship. The problem is here that you're saying we shouldn't be able to apply it to a sole proprietorship. We should somehow, some way collapse 405 notice to the insurer with the 300 notice to the employer.
And I would say because of the ambiguity, that gives the court more liberty to ascertain the legislative intent. The legislative intent is that the financially responsible party, which is probably 98% of the time.
I might disagree with you. I think the legislative intent was to make it easy for the employee to give notice of the injury. And the employee doesn't necessarily know who the employer's insurer is. The employee knows who their employer is, and therefore the injured employee's bar for notification is very low. Just let your employer know you were injured at the workplace.
I mean, that would make sense, I think, in just the typical employee situation. But in this case, you have a business person who is not, you don't want to infantilize them. They're a business person, they're in business. A sole proprietor has likely, just as this individual did, Mr. Heater, himself contracted with the insurance company.
I understand that, but that doesn't raise this to a level of, I don't think that makes this ambiguous. I am not sure how it gives rise to an ambiguity.
Well, again, I suppose, I guess it's really the two things that you look at Section 311, it says employer. Well, how do we interpret the term employer? There are two different definitions in the Act. This court has already said that, that gives rise to an ambiguity. There's also an ambiguity because you have to look at sort of different parts of the act and try to treat them as a whole. So you have the ambiguity, and then you determine what the legislative intent is. And I think in this case, we know what that intent is.
Let's just stick with the notice of the employee to the employer. What's the legislative intent behind that provision?
To prevent, do you mean 311?
To prevent what?
Prevent stale claims, to make sure there's timely notice. You can investigate a claim. They have 120 days after which the claim is barred. So otherwise you could give notice.
But isn't there an added part of that is to basically say to the employee, if you're hurt, let your employer know. Isn't that the intent?
Well, certainly that's part of it. I mean, you would, of course, employer would need to know, and you would, everyone.
Yeah, but the employer doesn't always know. You may have litigated these cases. I've seen them plenty of times. That, you know, a lot of reasons why an employer issues a notice of compensation denial is because they did not get timely notice of the claim. The employee sat on it past the period.
Right, but we don't. Those are fact specific. We don't know why they didn't get notice. It could have been I mean, maybe I'm going back to one of the first questions when I talk about how would a sole proprietor or how would an employee know to note who's its employer's insurer is.
Well, what if they did know? Like, suppose we rule in your favor, and then the next case comes along, and the employee, on the strength of the decision in this case, then says, well, I'm just going to notify the insurer, and then faces an argument, a forfeiture argument, because they never complied with 311, they never notified the employer.
Well, we're asking for a very narrow ruling like the Commonwealth Court did, and just in these narrow circumstances, because we don't think that every employee should always have to notify the insurer.
So that's a problem, though. Mm-hmm. We can't craft an exception for circumstances. We either interpret the way we interpret a statute has to apply to every circumstance. And your argument relying on Kramer would require us to say notice under 311 requires a notice to insurer always. Otherwise, we're saying it means one thing one time and something else a different time.
But then I think we go back to the definition of employer.
But it would always be the definition of employer. It's Justice Robson's point. We can't define employer one way when there's a sole proprietorship and define it another way when it's not a sole proprietorship. I mean, it's either employer means what it says pursuant to what appears to be the plain language, or it means it is the insured. And reading it that way really does away with the burden that's put on the employer under the Act, which is to notify the insurer. You wouldn't be here if this employee who notified his employer, which happened to be the sole proprietorship, and then notice was immediately given to the insurer. You wouldn't be here.
There wouldn't have been any violation of Section 311.
Exactly, because the employer gave notice to the insurer.
Right. We actually have a pretty straightforward issue here, and I think we all understand it. Do you have anything else you'd like to say in conclusion?
Just simply that this is the only interpretation, that the statute's ambiguous. It's the only interpretation that gives effect to the legislative intent, and that is intent that the responsible party has notice of claims, because in this case, because otherwise you create a class of claimants, sole proprietors, who have no responsibilities or notice whatsoever. They are only constrained by the 3-year claim petition statute of limitations. Every other claimant is constrained by the 311 notice requirement, but you have sole proprietors or their own employers, and they don't have any notice requirement. They won't forfeit anything unless they don't file their claim petition within 3 years. And we know from, this is not, it's just not pie in the sky or speculation. This happened precisely this way in this court, making the insurer financially responsible indefinitely for a catastrophic injury. And other claimants must report their injuries in a timely way. This individual did not, and there's potential for malfeasance, but also just potential that there won't be that disinterested third party in there investigating the claim, and all of that time in these circumstances is controlled by the claimant.
All right, thank you both very much.
Mr. Siegel, you could stay another day, but we won't be.
Mr. Minner?
George B. Thomas versus Sysco Foods, representing Mr. Thomas, Mr. Kenneth Kapner, representing Sysco Foods, Ms. Lisa Miller.
This case involves an employer's petition to modify a claimant's workers' compensation benefits based upon the claimant's earning power assessment as derived from a labor market survey. Section 306 of the Workers' Compensation Act addresses a claimant's partial disability and states, if the employer has a specific job vacancy the employee is capable of performing, the employer shall offer such job to the employee. Based on its 2008 decision in Rosenberg, the Commonwealth Court held that Section 306 requires only that an employer offer a claimant an open position within the claimant's restrictions, but does not require the employer to prove that no vacancy exists. Rather, the court found that the initial burden lies with the claimant to prove that the employer had a job vacancy within the claimant's restrictions. And only then does the burden shift to the employer to rebut the claimant's evidence. Finding that the claimant presented no evidence of a suitable vacancy with the employer, the court held that the employer's modification petition should have been granted. We granted allowance of appeal to determine whether this court should reject the Commonwealth Court's decision in Rosenberg and hold instead that the employer bears the initial burden in a modification of benefits proceeding to prove that no job vacancy existed within the claimant's work restrictions. I hope I got that right.
Beautiful, thank you.
Please proceed.
May it please the court, my name is Kenneth Kapner, and with my co-counsel Daniel Siegel, I represent the appellant George Thomas. Preface, this is technically my first time before this court this century.
Okay.
I apologize, but it's like...
How did you keep Mr. Siegel from arguing?
I'm sorry?
How did you keep Mr. Siegel from arguing?
Oh, I know. I had to fend him off on this one.
Okay.
Yeah, he's a superstar. I can't, seen enough about what he does. And the summary sort of suggests the problem we have here, because this is a case where there are credibility findings, and the judge made them, and followed the Pennsylvania Code. And the Pennsylvania Code 123.301 very clearly describes for the judges the framework of how you view the evidence and who has the burdens in moving forward. And it's interesting because the Commonwealth Court took something that it's been ingrained in the workers' compensation field, going back to Barrett v. Otis Elevator back in 1968, that the employer bears the burden of proof in a modification petition throughout the modification petition. And that was reminded by Kaczynski, reminded by the Phoenixville Hospital case, which I think Justice McCaffrey was the author of, and Chief Justice Todd, I think, also was on that panel. I take that back, it wasn't a panel. And the Phoenixville Hospital case is what I'm leaning heavily into on oral argument here today, because I really see it as showing that there was legislative intent that the employer has to establish for all the jobs that they're going to produce that the claimant is allegedly able to do. They have to establish that the employer other than them, has a job available that is qualified vocationally to this injured worker. But somehow or another, the Commonwealth Court says, but you don't have to do the same thing for your own workforce. You don't have to look at your own workforce. You only need to look at other workforce. So what we have here is something that I call absurd, and I'm sorry to use that word, but I'm taking it from 1 PACS section 1922, which is quoted in Phoenixville Hospital by the Supreme Court. And it says there, the precepts that the General Assembly does not intend a result that is absurd, impossible of execution, or unreasonable, and that the General Assembly intends the entire statute to be effective and certain. So that's where Phoenixville Hospital set the standard that, well, if the employer is going to produce jobs, it's not just any jobs that are out there. They got to show that they're actually available and the claimant actually is qualified for those jobs. So that's where we walk into this new situation where my client, who's a union worker, so he belongs to the Teamsters Union. There's a collective bargaining agreement between the parties, between the employer and the union, let's put it that way, and my client's a third-party beneficiary. So you also have something where the code addresses and says, well, if there's a union contract, you must go through the union contract to resolve, to bring the claimant back into the workforce. And in this case, as we saw from the supplemental record, there was a later labor market survey litigation. And in our immediate case, they claimed they were going to call Kathleen easily, and they never did. So there was never any cross-examination. They didn't produce any evidence, and they walk away on appeal with a victory. So the second absurdity is, Kaczynski talks about good faith. Okay, good faith. What is good faith? Well, good faith is the employer has to produce evidence of jobs that the claimant is able to do, and then the claimant has the good faith burden of going through and either applying for the jobs or something else. But the claimant has good faith duties, the employer has good faith duties, but now the employer doesn't have to show good faith all the way through their case in chief. They can avoid some of what their duties are, and suddenly they can be, like in our case, I call it bad faith, when there were two jobs that the contract allowed the employer to offer light duty to bring the claimant back into the workforce there. That never came up in our case because their witness never testified, and they just decided they weren't going to move on with it. So the judge made a great credibility finding. It was great because she read between the lines exactly what was going on there and said that if they produced Ms. Easley, what would have the outcome been? Because I would have had cross-examination and maybe put on further evidence to dispute whatever she was going to say. But so at this point, we're looking at a situation where my client, who's, he's pretty much the victim of this whole situation. He had a terrible injury, out of work for a little over 2 years, and they start the labor market survey route for him instead of going to the union and working on a plan to bring him back to work like they should have done. So this
But they could have, you're saying it was sort of a binary choice. They also could have gone to the labor market survey and said, we don't have jobs within our, put aside the union aspect of it, and let's just think about the act. Your argument is, in order for someone to go the labor market service route versus just offering a job within their restrictions after they do the IME, they have to show that they have no jobs within those restrictions such that the worker is on notice that they have to go out and find a job. That's your point. Regardless of the union stuff, you're just asking us to interpret the act to basically say that.
Yeah, essentially, and it's aggravated by the fact that this is a union employee and there are facts that show actual work was available that he could have been offered. And if they are able to go to the labor market survey after that, that's up to this court. But before that, there was a duty to offer those jobs under the contract. And if he didn't, that may have been a basis to file a petition for modification or suspension.
But does it matter whether there are jobs? I mean, to the point, I know belt and suspenders, you're trying to prove that there was jobs available, but under your legal principle and what we took it, doesn't matter. Because you seem to be arguing the legal issue, which is before an employer can move through the labor market survey route, they have to first establish, which arguably shouldn't be that hard,
Right.
that they do not have a job within the restrictions as reported by the IME.
Yeah, exactly.
And they didn't do that here.
I can't say any better, and that's exactly what did not happen in our case. I could add some other absurdities if you'd like.
Say that again.
I could add some other absurdities if you'd like.
I think we get it. Is there anything else you wanted to?
I have nothing more. Thank you.
Thank you.
Thank you. Let's hear from Ms. Miller.
Good afternoon, Madam Chief Justice and Justices. My name is Lisa Miller. May it please the court. I represent the defendant in this matter, Sysco Foods. As the Chief Justice properly stated, Section 306B2 of the Act requires an employer to offer an available position if such position exists, but it does not require an employer to prove the non-existence of such a position in a modification petition scenario.
But you can only go the labor market survey route if you don't have a job available.
In this case, our vocational expert confirmed with a representative from the employer that there were no positions available at Sysco within his physical restrictions. So that satisfies Mr. Diekman's testimony, if believed, would satisfy employer's burden.
Was it believed?
That portion of his testimony was not believed by the
Well, then we
judge.
can't do anything about that, right?
Correct.
So that's the problem, right? I mean, so you agree with the principle that you have to first show that you are entitled to go the labor market survey route.
And in this case, there was testimony that there was no job available with the employer. Now, claimant also argued that there were no jobs available for him. He was incapable of working in its entirety. And we agree that the Rosenberg decision does put him in an untenable position, given that his primary argument was, I'm unable to work at all. His secondary argument was based on his psychiatric expert that said he's unable to return to work for Sysco. It would be beneficial for him to return to work, but he can't return to work for Sysco. So those were the two, we would say, rebuttal opinions to job availability that claimant presented under Rosenberg. The Rosenberg burden of proof, it's our position, is a minimal burden for the claimant, and he did satisfy it by saying he couldn't work at all. Now, the judge did not find that testimony credible. He was inconsistent with some of that testimony. And counsel's second argument with regard to the labor market survey petition was that the jobs were not available under the St. Joe's container line of cases. And the judge found that the evidence presented with the collective bargaining agreement did not satisfy the St. Joe's container. He wouldn't forfeit any union benefits with regard to the positions located by the labor market survey. So it's our position that even though claimant's burden under Rosenberg is minimal, the Commonwealth Court's decision should be affirmed on appeal because there were no jobs available with Sysco. Claimant essentially proved that point for the employer, and the decision should be affirmed on appeal based on the labor market survey, which the judge found to be credible, and the appeal board granted the modification petition based on that labor market survey.
So is your position relying on the burden being on the claimant?
Initially, the burden is on the employer that under the labor market survey, and our vocational expert did confirm with Ms. Easley at the employer that there were no jobs available. So the burden technically shifts to the claimant to prove the absence of that, but in this case, claimant,
Well, you keep wanting to talk about this case. I mean, the interesting issue here, I thought, was this Rosenberg principle, if we can call it that the burden is on the claimant to prove a negative. I mean, the information, shouldn't we presume the information lies more with the employer than the claimant? Not only in this case, but globally? I mean, isn't the employer the one in the position to know about the existence or non-existence of work?
initially, yes. But in this case, we have to look at the facts of this case. And if you look at Rosenberg actually went back, she had returned to work in a modified duty position with her employer. She was subsequently terminated, and her testimony that was believed was there was work available at the employer. They should have offered us a job, or offered Miss Rosenberg a job at the employer, because she knew, and her testimony was believed, that there was work available for her at the employer. Here we had testimony from our vocational expert, which stated that he contacted Sysco and there was no work available.
And that was rejected by the WCJ?
Correct.
Which, what do we do with that?
It puts claimant in an untenable position, because claimant.
I think it might put you in an untenable position, because you can't, that finding is binding.
But it's our position that there was no work available, and claimant, if he was going to prove that there was work available, the witness was just as available to him to prove, or in the collective bargaining agreement, he could have put in, well, yes, these two jobs can be offered to him as part of the job availability issue under the labor market survey at Sysco, prior to beginning the labor market survey at Sysco. That evidence was not of record with regard to the two light-duty positions under the collective bargaining agreement until a subsequent modification petition was filed, which is not yet before this court.
Okay, I think we get it. Are there any other questions? Great. Thank you very much, Ms. Miller. Thank you both. Mr. Minner, would you call the next case?
George B. Thomas versus Sysco Foods at docket number 6068 2024, representing Mr. Thomas, Mr. Daniel Siegel, representing Sysco Foods, Ms. Lisa.
We knew you couldn't stay away from us, Mr. Siegel.
No.
This session will go down in history as the session of Siegel.
Yes. This appeal involves the same parties as our last argument, but concerns a petition seeking to terminate workers' compensation benefits. We examine whether an employer is barred from relying on a claimant's independent medical examination, otherwise known as an IME, where the employer did not provide the claimant's attorney with advance notice of the IME. In resolving this issue, the Commonwealth Court recognized the general rule that any notice required to be served upon a party must also be served upon the party's attorney. The court, however, declined to prohibit the employer from utilizing the IME as the claimant failed to establish actual prejudice arising from the lack of notice. The court reasoned that the workers' compensation judge afforded the claimant adequate safeguards by postponing the hearings for several months, which provided counsel ample time to confer with the claimant, to depose and cross-examine the employer's expert, and to provide the IME to claimant's own experts so as to prepare a report refuting its determination. Under these circumstances, this court must determine whether the employer should have been barred from relying on the IME in light of its failure to provide advance notice of the IME to the claimant's counsel. Please proceed.
Thank you. May it please the court again, I'm Dan Siegel, and if I could just, I've had a lot of cases here this session, but I couldn't have done it without my associate, who, you can't do this alone. And I just want to acknowledge Krista High, because she's an extraordinary attorney, and while she's not arguing, I can't do it alone.
You're channeling her legal analysis, I'm sure.
Did you ever hear of Justice Donahue's Project Litigate?
Give her the opportunity to argue. I bet she'd do a great job.
I wanted to, and she declined at this point, but there will be more.
She deferred to you, okay, just so she has the opportunity.
Oh,
Okay, please proceed.
in this case, there's a couple of issues, and they all sort of congregate or coalesce, better is the better term, as one. The IME, or the defense medical as they're often called, occurred without notice to the attorney, and as a practical matter, that IME was tainted. You can never remove the taint. And in this case, if you would see and we cite in the briefs, the questions that were asked of claimant by the psychiatrist, these were questions that went far beyond the medical examination and went into things about his conversations with his attorneys and other things. Once those are out, they can never be brought back in.
But how would they, if you would have gotten notice, what would have prevented the IME doctor from asking those questions?
Well, there's two issues to that. One is an attorney prepares his client for the IME and can, to a certain extent, help the client where he understands what he should be talking about and what he should not. The problem is also, though, that when you have a doctor and a claimant, or a doctor and a plaintiff, there is no ability for an attorney or a representative to be in that room.
And that's always been the law, right?
That has been the law since the act.
So other than the doctor's going to take a history regardless, right?
Well, the doctor can take a history, and she had multiple examinations of him. But the doctor can take a history of an individual, but she can go further and pry into other questions, which revealed she did here. And there was no ability for the claimant's attorneys to be present in the room. I acknowledge that under the Act, and it's been that way since 1915, since it first was passed, does not allow for anyone other than a physician of the claimant to come into the room. Well, as a practical matter, that doesn't happen. I've never seen it in my career. I have had physicians bar me from the examination or anyone else. And so, while in other cases I have said this court has to be constrained by the Act, this case is different because under the rules of professional conduct, for example, confidential information under Rule 1.6 is revealed, and that's never going to be able to come back. You can't, once you reveal information, it's revealed. You also have no ability to constrain or have any idea.
There's nothing, that's what I don't understand, is you could make all those arguments below in an effort to get the WCJ to strike the IME. And what I think you're asking for is a per se bar. If the notice of the IME is not given to the physician in the Act, we should read into the Act a consequence that applies every time, which is IME is bad and tainted.
Yes.
That's not in the Act.
That is not in the Act, but it is in the regulations to the extent that it says in the 13111 that any notice or written communication required to be served upon or furnished to a party shall also be served upon or furnished to the party's attorneys.
Well, where's the consequence?
But that's the problem. It's left up to the discretion of the workers' comp judge. And
Well, isn't that how it should be? Because you could make a proffer to the WCJ about underhanded conduct by the physician, or that the physician was serving as a de facto agent of the comp carrier for purposes of getting an illicit confession or something. Wrong word.
I
confession.
understand.
Admission.
That shouldn't there be, rather than an automatic striking, shouldn't there be a burden to show where the exam went over the line.
Yeah, upon motion by the plaintiff's attorney.
Problem with that is claimants are lay people. They are not educated. They are not going to be able necessarily to even remember what happened in an exam, let alone they often are so flustered by an examination that they don't. That's why.
Well, that doesn't help you.
Well,
Because you don't get to go in the exam. You could prep the client up, down, sideways, and the client could still go in the room and, under your theory, not remember the prep and answer these questions.
but in the same point, and this is why I'm suggesting in this case that this court needs to issue some rule that applies to all exams. And you can't issue a rule that's going to, like, well, maybe the comp judge is very simple. This court issued Rule 4010, and there was no statutory basis. It was in the Rules of Civil Procedure, and to avail themselves, and so that to prevent this type of abuse. And
These are not civil proceedings.
I understand.
These are statutory executive branch proceedings where the rules of civil procedure don't apply and where we don't have authority to regulate procedure.
But you do have an authority to regulate that, or to protect the rights of individuals, such as the claimant, to have counsel or to have.
What right to counsel did your client have in the IME?
He has a right to have his counsel or someone present, not to answer questions and other.
No, but where's the right? I'm asking you, where is the right?
The right is in.
You referenced in your briefs a constitutional right to counsel. Where is there a constitutional right to counsel in this
Not
side?
a right in the sense that you have a right to an attorney and it's a court-appointed attorney. But there's a right to counsel, and it's explained in the explanatory comment to Rule 4010, where you talk about the protections under the rules, including the right to have counsel or another representative present at the examination. There's no.
At what examination?
In the physical or mental examination under civil.
In a civil case.
But there's no constitutional right to that either. This court read it in when it wrote the rules, and Justice Mundy, when she issued
The rules for notice, you mean?
the rules for notice and the rule that a party has the right to have counsel present or a representative of counsel present, and Justice Mundy commented on that in the Shearing versus Hafer case and literally presaged the facts here.
I don't have a problem with that. And we have a constitutional power
Yes.
to establish rules that govern civil proceedings in our courts. We have zero power under the Constitution to establish rules that govern administrative agencies.
Well, I think you do, in the sense that when you see a deprivation of a right, an inability, the IME is nowadays, if the doctor wants no one there, no one is there. No one can be there. And that's not, the act was written, didn't contemplate attorneys, didn't contemplate litigation. There was none of that. There were no fees for attorneys. There was nothing. It was meant, and it was expected to be a very different situation from what it is now. And IMEs, unlike IMEs in civil proceedings, are much more serious in workers' comp, because the employer is entitled to 2 examinations a year, and they get them regularly, as is their right. The claimant has no right for any person to be there. Almost always, they are the central issue in termination proceedings, claim petitions, modification petitions, and as a practical matter, workers' comp attorneys handle way more depositions than any civil attorneys do. In the days when I had a larger practice involving claimants, it was not unusual to have 1 or 2 depositions a week because of all the examinations. But my colleagues in the same firm who had civil cases might have 1 doctor deposition every 6 months or a year because they didn't come up. They come up all the time.
Fair enough. Well, rather than create, and maybe I'm misconstruing your position, but rather than creating a categorical rule that would strike any IME where this happened, why isn't the prejudice standard the proper remedy, given that you appear to have been given process here to develop any evidence of skullduggery, subterfuge, deliberate misconduct, prejudice, what have you, rather than the draconian penalty of striking the IME categorically when something could have been overlooked, or there could have been a mailing error or what have you?
Well, I can tell you what I think the court should do. Obviously, you're going to craft that solution, but the solution that we have now is no solution. And when you have a case where counsel is representing both the third party and the employer, it comes in and it's potentially more problematic.
Well, I don't understand why you're saying there's no solution. How would everything, had the right counsel gotten notice, what would have been different?
He would have been able to protect more, at least prepare his client, maybe object to the exam.
Well, I understand by that, but that's what I think would have been a great argument by your part, because if the IME was not authorized by statute, meaning they noticed it too soon or too late or whatever the rule is, or they had the wrong doctor or something like that, and you weren't able to effect that objection in advance of the IME, you could have made that argument here, but that's not the argument you're making. You're just making, under every circumstance, we don't even need to know the facts. When there's a violation of the regulation in the statute, something we don't create, we as a court get to say what the consequence is, regardless of whether there's any prejudice.
Well, that's why I still believe that this court should craft some rule like 4010 for purposes of workers' compensation, because you're not violating anyone's rights by doing so. You're protecting the individuals. You're addressing the global situation that occurs by saying, you have a right to have a representative there.
Well, you don't.
But
the statute doesn't give you a right to have a representative there.
I understand that.
So you're asking us to override the General Assembly's judgment.
In this case, I am. And I know I've taken contrary positions very recently. But this is a different situation which this court, or in its rules, have said is a constitutional protection of an individual. When the constitutional...
I don't think we've said a constitutional protection. Where do you have a constitutional right to counsel other than in the criminal context?
The protections under subdivision A include the right to have counsel or another representative.
Right.
The right to have counsel.
Statutory, right.
There is no statutory right.
What are you reading from?
The explanatory comment to Rule 4010. And
Counsel, can I just ask you to assume for a moment that we can't craft the right to have counsel present into the Workers' Compensation Act? Would it be a clearer rule for us to say that if notice is not given to counsel, the IME is void and a new IME has to take place with notice to counsel?
that would solve a lot of the problem. I would suggest further, though.
I would not suggest further. I mean, the statute says what it says.
Yeah.
I mean, and you're suggesting, I think, that we should presume prejudice.
Yeah.
If the claimant didn't have the opportunity to, A, have his counsel aware of the IME, or to have counsel consult with him prior to the IME. So if counsel does not give notice pursuant to the code, then the IME is void and a new IME would be ordered with notice to counsel. Is that a clear enough rule?
A new IME with a different physician?
That's what I was going to suggest.
Well, it would almost have to be if the possibility of taint exists.
Yeah.
Right?
But isn't it a reasonable solution to do what Justice Wecht was talking about, where you could make
I thought you were going to say so eloquently expounding upon, but
I was getting to that, where you could make a notice was not given to the attorney. The attorney could make a motion and show that there was some prejudice. If you could demonstrate some prejudice to your client, to the case, then you get a new IME rather than an automatic striking of the IME because there was no notice.
Well, it's a lot clearer if it's a striking than the other, because then you're adding
It is.
further litigation, further motions. In some cases, it may be an IME that wasn't even, that's not involving litigation, where the notice was just sent, you know. There are cases, they have IMEs all the time, where there's no litigation. We're going to send him or her to an IME, presumably to find out if she's fully recovered. But so it has to be, as a practical matter, something that covers all claimants. The Act covers all claimants. It just says there's a medical examination, and you can only have your physician there. Physicians aren't going to go, and they never have, not in my 40-plus years of practice, ever to an.
Well, your problem with that is the dispute, that dispute lies with the General Assembly.
I understand that. But that, I don't believe that you are powerless to do nothing. Because this is not a situation where we're trying to craft something that doesn't, that they are entitled to a protection. And right now, they are protectionless. And
You keep saying that, but what's wrong with what the WCJ did here and said, look, there's no per se bar in the Act. There's clearly a requirement. You didn't give it. I'm not going to strike the IME. I'm going to give you all these ameliorative things and take care of the prejudice. Your argument to the Commonwealth Court then on appeal or to the board could simply be, that wasn't adequate. It was an abuse of discretion to not strike the IME under the circumstances as I presented it. And then the Commonwealth Court could say, or the board could say, yeah, it was an abuse of discretion. You should have struck the IME. Isn't that better than just us from up here saying, oh no, if the notice isn't complied with under the statute, everything is out?
no, because with what that does is it creates more litigation, more question marks, when if you have the rule, everyone's playing by the same rules, everyone knows what they have to do.
But you're going to have the same litigation anyway.
No,
You're now going to have double. You're going to have the same litigation anyway. You're still going to get a second IME.
yeah. But if, like in this case, the taint was already out, and I believe, and you can look at the record for yourselves to determine whether you believe so, but the record indicates Dr. Fenichel, a psychiatrist, presumably very knowledgeable in how to question people about things, was prying well beyond what she should have. And once that's out and gets information that is your discussions with your lawyers about whatever, including a settlement or whatever, that's never coming back. And that can...
So maybe the WCJ abused its discretion in not striking it.
Oh, I think
then we could certainly review an abuse of discretion and say it's an abuse of discretion.
Yeah.
Okay, I think we understand. Anything further, Mr.
No, thank you.
Well, thank you both very much. This will conclude our 2025.
I guess I don't need to respond.
Oh, my goodness. Did I cut you off? I certainly did, and I apologize.
That's okay.
Sincerely.
Justice Robson did a wonderful job. That's my argument in summary.
He was making your argument.
However,
please forgive me.
Good afternoon again, Madam Chief Justice and Justices. May it please the court. Again, my name is Lisa Miller, and I represent the employer here, Sysco Foods. With regard to notice, the notice issue of this IME, claimant was involved in active third-party litigation here, and the notice of the IME went to his third-party attorney as there was still active litigation at the time of Dr. Fenichel's third evaluation.
Not to his workers' comp attorney.
Correct. It went to his third-party attorney. There was still active litigation at the time of her 2020 IME in both the third-party case and the workers' compensation case. So it's our position that claimant did have the benefit of third-party counsel.
That's an oops.
Yeah, especially
That's an
under
oops.
the...
You should have noticed the workers'
especially
comp
under the
counsel.
rules that 4010 that counsel was citing to, under the rules of civil procedure, he did have the benefit of counsel if he so chose.
There's no mistake here that the IME was for the purpose of the work workers' compensation action and not the third-party action.
No, the IME was done for the third-party case. The third-party case was still in active litigation. They were going along on two parallel tracks.
But it was also for purposes of the workers' comp action?
Not necessarily for purposes of the workers' compensation action. There was already...
How did you get into the workers' compensation case then?
We were provided with the IME report with the full recovery opinion after her third evaluation, which
So this
formulated
wasn't the workers' compensation, IME?
It was an IME for purposes of litigation. It didn't
That wasn't
differentiate,
my
however...
question. You used it in the workers' compensation case. Was this an IME pursuant to the Workers' Compensation Act?
It was under the Workers' Compensation Act as well as...
Why can't you just straightforwardly concede that a mistake was made?
Yeah.
Because it was a comp IME. It wasn't for the tort case, right?
No, it was for the tort case.
It was utilized.
It was utilized, but this was arranged through the comp process, right?
No,
No?
no, it was not. It was arranged through the third-party litigation.
Was this a comp-approved doctor?
It was the same doctor that was utilized in the workers' compensation matter. Dr. Fenichel had seen
Board
Mr.
approved,
Thomas
on the list.
on 2 prior occasions.
On the list?
It
Board
doesn't,
approved, on the list?
it doesn't have to be on the list, but it was on, Dr. Fenichel saw Mr. Thomas on 2 prior occasions for the workers' comp claim, and litigation ensued from those two evaluations.
If I were the counsel for the claimant, I would have objected to the IME at the outset since it was on a workers' comp IME. I don't know that you can use IMEs other than ones that are through the board panel physicians and go through that process.
If the council got notice of the IME.
Well, but he could have made that, they could have made that objection below. I'm just saying they didn't make that objection, but this got more complicated. It got curiouser and curiouser.
But this IME was used to impact this claimant's workers' compensation benefits?
Yes.
Correct.
Okay. And this claimant had counsel for workers' compensation purposes who did not get notice of this IME?
He purportedly did not get notice of the IME.
Was it sent to him?
No, the notice,
Then he didn't get notice. I mean, the regulation is clear. I mean, notice has to be given to the workers' compensation attorney. I mean, you have a very straightforward argument here because you're relying on what the lower courts did. But I mean, the facts are the facts.
in this case, claimant's counsel never presented any evidence that the third-party attorney who he closely was working with, because the third-party case was also in litigation, that no one had notice of this third evaluation.
Why would he have to, he would have to establish that as the comp attorney, he didn't get notice. Why would he have to, what else would he have to establish?
It's our position that the IME went forward, the judge provided him with the safeguards of rebutting the IME opinion. He did have the benefit of counsel.
That doesn't address the issue of preparing him for the, I mean, there's a lot to be said for preparing a claimant before his IME, at least so he knows the parameters of what a doctor should and should not be doing during the IME. The claimant could go in thinking he's subject to an interview rather than a simple medical examination.
His third-party counsel under 4010 had that benefit of consulting with counsel.
Isn't there
Counsel.
That's understandable, and this was the third evaluation by Dr. Fenichel. If this was the first evaluation by Dr. Fenichel and she didn't have his whole entire history, I think it's a different scenario.
Well, can I ask you a question procedurally? Because again, I was a little bit confused. Are you counsel in the third-party case too?
No, I
Okay.
was not.
How did you become aware of this civil IME?
We got the IME report from the doctor, from Dr. Fenichel.
That was done under the rules of civil procedure.
I believe so, yes.
Okay. Is there any question that the rules of civil procedure were complied with when that IME was done?
They received notice.
That's not what I asked. Is there any dispute as to whether the requirements of our rules of civil procedure were followed with respect to the IME?
I don't know. We didn't send the notice out.
No one did to Comm Council.
Obviously, claimant got notice.
See, there was no way for you to even comply with the workers' comp notice requirement because by the time you learned of the IME, it was done.
Correct. That's correct.
Huh, curious, sir.
And curious, sir.
Counsel, let me ask you a question. If the court determined that there should be an enforcement mechanism for the notice requirement to counsel for the claimant, how about just the rule being if notice isn't given, the IME cannot be used, new IME doctor, notice to counsel?
Well, it's our position, just looking at the facts of this case.
I'm asking more as a general proposition here, counsel. I mean, number one, I don't know how often this happens. Okay, that's number one. But it would seem to me, if the rule was clear that if you don't give notice, you don't get to use that IME, you'd probably always get notice to workers' counsel.
Yes, that would be the case.
That would probably happen, right? I mean, I don't know
Yes.
that it happens all that frequently or not otherwise, but certainly if you're precluded from using an unnoticed IME, notice would be given.
I think that would be the case. However, in this case, notice was clearly, claimant received the notice of his IME.
The claimant did.
It was sent to claimant's third-party counsel because it was being used in reference to.
I understand that, but I'm really focused on the idea that his Comm counsel was entitled to notice, which he was. He was entitled to notice. And I don't think anybody disagrees with the fact that Comm counsel did not get notice.
He purportedly did not get notice. He could have talked to his client.
See, I think
get notice.
I think we might have authority here, and tell me why I'm wrong. The IME that you tried to use here was an IME taken in a civil proceeding under our rules of procedure, correct?
It was an IME that was intended to be utilized for the third-party case.
Which means it was pursuant to the rules of civil procedure.
That's my understanding, yes.
So we could create a rule or a ruling that says IMEs done in civil proceedings pursuant to the rules of civil procedure cannot be used in the workers' compensation context unless advance notice is given pursuant to the act. Because we do have the power to do that, right?
But under Section 314, that's something that the legislature is going to have to address.
No, we can amend our rule and say that. We can amend our rule and say, you, executive branch agency, do not have our imprimatur to use our court-sanctioned IMEs under the act. That's our power.
But I still think that under the Workers' Compensation Act, that's something that the legislature has to address.
Why is that? Why are we without the ability to fashion a remedy? I mean, even if it weren't the rules of civil procedure, why do we not have the authority to fashion a remedy
To a rule that exists.
to this notice requirement? Certainly, if the lower courts can do it, we can do it. I'm pretty sure about that one.
That's correct. However, it's the Workers' Compensation Act, and under the Workers' Compensation Act, the rules of civil procedure don't necessarily apply.
Yeah, I'm not talking about that. I'm talking about, forget about the fact, just like keep this like as narrow as possible. Workers' Compensation Council did not give notice of this IME. Didn't happen. The remedy for not getting notice is that the IME cannot be used, start all over again, and give notice to counsel.
It's our position that in this case, the judge under the rules, allowed the IME to go forward and gave claimant the safeguards that are under case law, under the Marnack case, in order to rebut the evidence that was presented during the IME that was done here. It was the third IME. The prior IME was done a year before, so under the Act, it was more than 6 months under Section 314. So it's our position that there were safeguards here. Claimants got notice, third-party counsel got notice, and it's disingenuous for claimants' workers' compensation counsel to say that he didn't know what was going on in the third party.
It's not disingenuous. It's his saying he didn't receive notice, which is a fact.
Under the timeline of this, after Dr. Fenchel's IME of this claimant, you filed a petition to terminate or modify?
Correct. We filed a termination petition.
Doesn't that make it even worse? Because you're saying, you keep arguing this was the third time they did an IME. Did you file a petition to terminate or modify after the first two?
We filed modification petitions after the first two, and that was the labor market survey, underlying labor market survey petitions. On this case, Mr. Thomas sustained a specific loss of his leg. So the psychiatric or psychological injuries that Dr. Fenichel addressed were separate and apart injuries. So this was not a full termination petition. This was a termination petition to address the separate and apart psychological or psychiatric injuries that he sustained.
But you were using the IME of the physician that was taken without notice to his counsel, basically to cut his benefits.
We were taking that deposition to terminate his psychiatric or psychological benefits, not to terminate him completely.
I think that's really, that in and of itself is a layer of prejudice that I think would be hard to unring.
Thank you.
I think that. I don't know if they do.
Is there anything else you want to say? We understand your argument. Well done.
I would just like to, address that the court should affirm this decision on appeal.
We understand. Thank you very much, Attorney Miller. And again, I apologize for nearly cutting off your fine argument. Thank you. Thank you both very much.
Thank you.
This now concludes our 2025 argument session. I would like to thank PCN for filming and broadcasting our argument sessions for their educational purposes. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, for their outstanding service to the court, along with our court security, John Evans, Gary Shovlin, and Scott Town, and the Capitol Police for providing security to the court and to those in the courtroom. Mr. Minner, you may adjourn court.
Happy Thanksgiving.
Thank you.